Alrighty, all rise.
Please be seated. Thank you.
Good afternoon. I'm going to do a brief introduction about Judge Carrigan, and then perhaps we'll have introduce parents, and I'll turn things over to Justice Hood. So my father, Jim Carrigan, I want to first of all recognize Beth Carrigan, my mother, who's here today. She's 92 years old, and sharp as a tack, and that wise at her age. My father, Jim, loved this law school. I'm his sixth child, and we called the law school his seventh child. He taught here. He was a full-time professor here in the 60s. He had 3 kids attending get their law degrees from this university. And then when he was appointed by Governor Lamb to the state Supreme Court, so it's a tremendous honor to have Justice Hood here join us. That's one of the jobs he held. And then, being a trial lawyer, he had a passion for being a trial judge and was appointed to the federal district court, where he served for many years with great distinction. And while he was a judge, he continued to teach here. And what he would often do is, it's funny, when you're a judge and you ask a prominent trial lawyer to come talk to your class, they say yes. So he got a lot of trial lawyers to come in and talk about what they did successfully. And through those introductions, many of the law students end up getting jobs. So I know he's up high, looking down on all of you, and we're so grateful for you taking your time and talents to be part of this competition. And thank you so much for being part of the great Carrigan Cup history. With that, Justice Hood.
Are we gonna get more introduction?
I think inter-counsel.
No, but I just wonder, you had suggested in there that we might say a little bit more
Please.
about it, but I don't want to bore them with that. You want to just jump in, or?
I can just very briefly
Yeah.
say, my name is Jessica Brown. I'm a partner at Gibson Dunn. I clerked for Judge Carrigan. It was an honor and so special to me to this day, and it's a pleasure to be here with all of you.
And I'm Will Hood. As noted, I am on the Colorado Supreme Court, and it's my privilege to be here to, in part, honor the legacy of Jim Carrigan, who was not only a member of our court, but a federal judge, and was such an icon in our legal community for so many years. So it's a real honor to be here. I should tell you, sort of relevant to what we're doing tonight, I was also a trial judge for about 7 years on the Denver District Court bench, and a trial lawyer for about 17 years before becoming a judge, 10 of which I spent as a DA. So bear with me a little bit. I'm going to have to shake some cobwebs off while we do this today, but hopefully there'll be some muscle memory. So why don't we go ahead and do entries of appearance, starting with the prosecution, please.
Yes, Your Honor. Alexis Offer and Caitlin Dacus for the people.
Alexis, and what's the last name?
Offer, O-P-P-E-R.
Okay. And
Caitlin Dacus, Your Honor.
give me the spelling of the last name.
D-A-C-U-S.
Okay.
Your Honor, would you like written entries of appearance?
Why not? As long as you have them, you're welcome to approach. Thanks so much. And for the defense.
Good evening, Your Honors. My name is Phoebe Schneider, and I, along with my co-counsel Suchinder Kalyan, represent the defendant in tonight's case.
All right, thank you.
Would you also like written entries of appearance?
I suspected you were going to offer something. Please, you're welcome to approach. Thank you.
Clerks.
And remind me how to pronounce your name. That went fast, so go ahead and.
It's Suchinder Kalyan, Your Honor.
Okay, Kalyan, Mr. Kalyan, thank you, sir. You're welcome to be seated. All right, I understand there are some motions in limine that we need to address. Let's start with the people. What motions would you like me to take up?
Your Honor, actually, prior to before presenting motions in limine, the prosecution requests to present some housekeeping matters that we have stipulated and discussed with opposing counsel for the purposes of mock trial to discuss what we have agreed upon so far as constructive movements and so forth.
Okay. You're welcome to do so from there. We'll just imagine if we were in the presence that we're doing it at the bench. Go ahead.
Yes, Your Honor. We are requesting permission to move about the well during openings, closings, crosses, and directs.
Sure. You may.
We are requesting permission to constructively approach the bench.
You may.
We are also requesting that we constructively sequester two of our witnesses in today's case. On the defense, Ms. Terry Tayo, and for the people, Ms. Duke Remington.
That's fine, thank you.
We've also agreed to stipulate a couple of our exhibits. The exhibits that we will stipulate to are A, B, and C. We're stipulating them as admissible.
All right.
We also believe that one of our witnesses, Detective Taylor Weiss, may find it useful to create a timeline in presenting her testimony. This timeline it's just blank for now, but it's set up over here. Would it be okay for Detective Weiss to make her timeline appear, or would you like us to bring the timeline exhibit down?
Whatever's more convenient for you.
Yes, Your Honor.
Thank you.
Finally, we know that tonight is a jury trial, but may we address the three of you as we are speaking to our jury?
Sure, that's fine, thank you.
No more from the people.
Probably makes more sense than you looking away from us, right? Yeah,
That's right.
thank you. And for the defense?
Yes, Your Honor, we only have a few more housekeeping matters. We request that all stipulations from the case packet be constructively read into the record,
Done.
and that all jury instructions be constructively read to the jury.
Done.
And lastly, the dates of our trial, just for clarity purposes, have moved up to 2022. This event occurring in 2021, 22 trial in 2022, as opposed to 2004, 2005, which you see in your case packet.
I've heard that, and I appreciate that you're responsible for the math.
Yes,
I've always said that lawyers should never do math in public.
you are correct. That is all housekeeping matters from the defense, Your Honor.
All right, thank you so much. And now the motions in limine.
Yes, Your Honor. From the people, we have three motions in limine here this evening. Our first motion in limine, Your Honor, is to exclude as inadmissible Exhibit D. For a little background, we are here in an insurance fraud case this morning with insurance fraud charges against the defendant, Dennis Sloan. This postcard in question was allegedly written by the ex-girlfriend of Ms. Sloan to her sister, Duke Remington, who is one of our witnesses here today. So Duke Remington received this postcard. Duke Remington also was a former employee of Ms. Sloan's. We have good reason to believe that defense counsel will likely try to admit this exhibit in order to cast suspicion upon Duke Remington, our witness, and her sister, who is not here today. We asked to exclude this postcard on the grounds of Federal Rule of Evidence 403, as well as 802 hearsay, Your Honor, and finally 901 authentication issues as well.
Okay. Any response from the defense?
Yes, Your Honor. First, I would point out that all exhibits in this case are authenticated as per the stipulations in the case packet. I will deal with the 801 objection first. Hearsay is an out-of-court statement offered for the truth of the matter asserted. The postcard in question here is a statement from, as opposing counsel mentioned, a witness who is not here to testify today, Ms. Coco Remington. This postcard was sent to her brother, Duke Remington, who is here to testify, her sister, Duke Remington, who is here to testify today. If I may make an offer of proof.
Please.
The postcard will be used to show Ms. Remington's state of mind that she is showing to her sister within her words. If I may, the words on the postcard state, "Thank you for helping me get what was coming to me." As such, this falls under the hearsay exception, present a state of mind statement under 8033. Furthermore, Ms. Remington, as I mentioned, is not here to testify today due to her unavailability. And the prosecution will confirm that she has been unable to be reached as a witness, and as such, under Rule 804, she is unavailable, and this falls as a statement against interest under 804b3. As such, we ask that this postcard will be admitted, the proper foundation will be laid then to establish that Ms. Remington can confirm the postcard was indeed written by her sister, Coco Remington.
All right,
Do you want to respond?
If I may,
Very
briefly. Your Honor, as to the 8033 exception, Your Honor, 8033 tends to indicate forward-looking intent and plans, and here this is just simply a thank you card. Under the 804 exception, Your Honor, the declarant who is unavailable, the offering party who is offering the statement must have shown that they themselves have, by reasonable means, have not been able to procure this person here, and I don't believe the defense counsel will be able to lay such foundation.
all right. I'll take the matter under advisement and make a ruling contemporaneously with the effort to admit the testimony. So you're stunned by this, I can see that. Next motion?
Yes, Your Honor. The second motion from the people this evening is a motion to keep out any testimony about Duke Remington, one of our witnesses' past crimes, specifically a crime that the defendant was recently released from prison for. We asked to keep this out under 404 as well as 403.
Response?
Yes, Your Honor. Under Rule 609A1A, a crime punishable by more than 1 year, a felony as in this situation, must be admitted subject to Rule 403 for a witness who is not a defendant in this case. For a little bit of background, I believe the crime that opposing counsel is referring to is a felony conviction for dealing in stolen property. This conviction belongs to Miss Duke Remington. This conviction occurred within 10 years, and she is still currently on probation for this conviction. The argument that we will be using this conviction for is to show this witness's bias in this case. And under 403, relevant evidence may be excluded only if its probative value is substantially outweighed by the danger of unfair prejudice. Here, the probative value of Ms. Remington's conviction is the fact that she is here today testifying on behalf of the prosecution due to a deal that the prosecution cut her. She's here because if she testifies truthfully, they will recommend her probation be terminated. As such, this is highly probative, and any danger of unfair prejudice does not substantially outweigh that probative value. We will not be using it particularly for that propensity argument that I imagine opposing counsel is suggesting.
Okay, brief rebuttal.
Yes, Your Honor. The opposing counsel has brought up a second issue, I believe, the probation issue, the agreement with the district attorney's office that Ms. Remington has today. Your Honor, we do not object to that coming in because, yes, there is certainly a bias argument with that, but that bias argument does not also cover the actual criminal conviction, which is for selling stolen goods, Your Honor, which also under 609 is not, the elements of which is not under 609 considered a dishonest act of immoral property.
All right, well, same ruling. Next motion?
Yes, Your Honor, our final motion today is based on Rule 615. For some background, Detective Taylor Wise is here. She is our first witness that we plan to call today, and she is our advisory witness. She has been essential in this case as the lead investigator into the alleged burglary at Ms. Sloan's home. As such, Detective Wise gave a deposition on this matter in January of 2022. 1 month later, in February of 2022, Ms. Sloan had her first trial, which she gave testimony, which is the sworn testimony that we have here before us today. Therefore, Your Honor, we believe that it is a permissible inference that Detective Wise is familiar with that testimony, and we ask that any information that she's going to share today based on her deposition that she learned about and in her investigation that is also corroborated by the former sworn testimony of Dennis Sloan in that trial be allowed to come in, Your Honor. We are requesting this because we believe the defense will raise a lack of foundation on some of the knowledge that the detective knows today.
All right, response.
Yes, Your Honor. Pursuant to 615, a party can have somebody as their representative witness. However, we object to this person being recognized as a representative witness in this case, given Officer Wise's limited capacity to testify as to what she saw. For a bit of background, Officer Wise will not be tendered as an expert witness in this case, and all of her testimony is knowledge based on hearsay, based on what she actually observed at the time of the burglary. As such, I believe opposing counsel is simply trying to designate her as their party representative to get around the hearsay rule, because most of Officer Wise's testimony will not be able to be corroborated if not for that exception to hearsay. As such, we ask that Officer Wise be sequestered along with the other witnesses and be able to tell what she actually saw during her investigation, with proper foundation being laid. We don't object to that particular part of her testimony. However, anything that she's heard from a previous trial is not relevant in today's case, as this is a new trial. The jury was hung in that situation, and we are here today to retry this based on the facts that occurred in October of 2021, not February 2022.
Brief rebuttal.
Briefly, to the hearsay argument, Your Honor, under 804A1, we have an unavailable witness in Ms. Sloan today because she is covered by a privilege and does not have to testify today. And we certainly cannot call her as a prosecution. Secondly, the exceptions under 804B include former testimony that was given as a witness at a trial, whether in this proceeding or in a different one, and therefore this prior testimony can come in as an exception to the hearsay.
Okay, well, it seems we have two issues, right? We have the 615 issue as to whether the witness considered advisory. That objection, to the extent there is an objection to that, maybe I'm not hearing one, so overruled. As to the hearsay objections, same ruling as before. We'll just see how the evidence develops, and I'll make contemporaneous rulings. All right, any other motions in limine?
No more motions from the people, Your Honor.
Thank you. And for the defense?
Yes, Your Honor. The defense has 2 motions in limine today.
All right,
Excuse me, 1 motion in limine today.
even better.
The defense moves to prohibit any conversation that Detective Wise had between a person named Clint, a manager of the Dewdrop Inn. For a bit of context, we anticipate that Detective Wise will testify to the fact that she went to the Dewdrop Inn, an establishment, to confirm the alibi of Miss Duke Remington and spoke with the manager, whose name is Clint. We have no information as to the last name of this person, how long they worked there, what their managerial duties involve, how she would have seen anyone named Duke Remington. As such, this is impermissible hearsay pursuant to Rule 801. We ask that it be excluded as an out-of-court statement offered for its truth to prove where Miss Remington was on the night of the burglary.
Response?
Yes, Your Honor. As to the hearsay exclusion for the conversation that Detective Wise had with Clint, the manager of the Dewdrop Inn, Your Honor, when Detective Wise testifies, we intend to bring this in under the effect on the listener, simply to indicate how this conversation affected the detective's investigation. And in our second witness, we will be able to bring this conversation in for its truth, because Duke Remington testified that she herself interacted with Clint at the Dewdrop Inn that night.
All right. You want to brief about this?
Briefly, yes, Your Honor. We expect that while opposing counsel says they will be using it for the effect on the listener, the jury will take it as truth to the fact that Miss Remington was in fact at the Dewdrop Inn, when the only person here to talk about that is herself today. As such, it is an out-of-court statement offered for its truth. The jury will perceive it as truth, and we ask that it be excluded.
All right. Once again, I'll take the matter under advisement, and you're welcome to renew your objection when the issue comes up, and I'll make a contemporaneous ruling. Thank you. Any other preliminary matters that we need to address?
I don't believe so, Your Honor.
None for the people, Your Honor.
All right. So give us just one moment, please. And people are welcome to provide opening statement.
Yes, Your Honor. May we move the lectern?
If you'd like, please.
Dennis Sloan was a desperate woman who wanted an easy out. Dennis Sloan was a wealthy woman who made her fortune by investing in oil and technology. And with that fortune, she paid for trips on private jets, a working ranch, and hundreds of thousands of dollars of fine jewelry. But when the market turned, Miss Sloan was at risk of losing the lifestyle she'd become accustomed to, unless she could come up With the $325,000 she was behind on her mortgage, Miss Sloan was facing foreclosure. But all was not lost for Dennis Sloan, because inside of her home there was a safe, and in that safe there were several pieces of fine jewelry, totaling in value over $380,000. And on the morning of October 29th, 2021, those pieces of jewelry were missing. Miss Sloan phoned the police, and then she submitted an insurance claim form to Lone Star State Insurance Company, requesting a payout of over $380,000. And the next day, she sent a package to a Swiss bank and insured that package for $385,000. She asked her longtime caretaker, Terry Tayo, to help her send that package. And to that caretaker, she paid $25,000 as a gift. Miss Sloan's problems were solved, or at least they would be, as long as Lone Star State Insurance Company paid her what she requested. But Lone Star State Insurance Company denied her request. They contacted Detective Taylor Weiss. Detective Weiss conducted an investigation, looking at Miss Sloan's home, talking to related parties, and looking into Miss Sloan's financial background and transactions, all to figure out if Miss Sloan was the victim of a burglary or if she had staged that burglary and fraudulently submitted an insurance claim form. Was she a desperate woman who wanted an easy out? Members of the jury, my name is Alexis Offer. Me and my co-counsel, Caitlin Dacus, are here today to prove to you beyond a reasonable doubt that Dennis Sloan is guilty of insurance fraud. That she took her fine jewelry, shipped it in a box, and sent it to a Swiss bank, meanwhile submitting an insurance claim form for that same jewelry. To prove this to you, we're going to call two witnesses. First, you're going to hear from Detective Taylor Weiss. Detective Weiss is the lead investigator looking into this case, and she's going to tell you about the investigation she conducted. She'll tell you about what she saw when she went to Miss Sloan's home, what she learned when she spoke with other people who worked on Miss Sloan's ranch, and what she uncovered about Miss Sloan's precarious financial situation and financial transactions. Next, you'll hear from Duke Remington. Duke Remington was a ranch hand who worked on Miss Sloan's ranch, and she's going to tell you about what she saw Terry Tayo, Miss Sloan's faithful caretaker, put into one of Miss Sloan's cars. She's going to tell you about the box she saw on its way to Switzerland. Miss Remington is also going to tell you about how she was fired, how Miss Sloan alleged that she was responsible for the missing jewelry, despite the fact that Duke Remington was at a local bar the Dewdrop Inn the night that that jewelry allegedly went missing. If the defense chooses to put on a case today, I want you to listen and see if they can explain a few things. See if they can explain why Miss Sloan insured the package she sent for $385,000 days after she submitted an insurance claim for just over $380,000. See if they can explain why, despite her $325,000 behind on her mortgage payments, Miss Sloan took out a withdrawal of $25,000. And see if they can explain why she gave that $25,000 to Terry Tayo, her caretaker, who she asked to ship that valuable package. Dennis Sloan was a desperate woman. And today, you have the power to decide if she's going to get her easy out.
Thank you. Opening statement for the defense.
Yes, Your
If
Honor.
you choose to present one now.
May I proceed?
Please.
Crippling coincidences. We are here today because of a series of crippling coincidences that made an innocent woman look like a criminal. October 28, 2021, Ms. Dennis Sloan received a phone call. She was invited to a charity event in New York City that very evening. Now, it was a quick turnaround, but she got her things together and she went. She left her house around 4 p.m., flew to New York, attended the event, and returned home the next morning. When she arrived home, everything was fine at first. She went into the side door, went upstairs to change, and it wasn't until she came back down the stairs that she noticed something was off. She walked into her den, saw that the safe door was wide open. Photos of her ex-wife smashed all over the ground. Her ex-wife's jewelry that she had been saving to give to their young daughter one day was stolen. So she did what anyone who had just discovered a burglary would do. She called the police, and she filed a claim with her insurance company. But the police didn't help Ms. Sloan recover her stolen jewels. And her insurance company never issued any payment. Instead, Ms. Sloan was indicted for filing a false or fraudulent insurance claim. My name is Phoebe Schneider, and I, along with my co-counsel, Chinder Kalyan, represent the defendant, Ms. Dennis Sloan, in today's case. You'll hear a lot about Ms. Sloan today. You'll hear how she's a successful entrepreneur in the community, and how, given her wealth and her status, was burglarized by the people she trusted in her life. But before you hear that, the prosecution will tell you a very different story about Ms. Sloan today. A story about a woman who was in desperate need for cash. But while they tell you their story, pay attention to the details they leave out, the things they choose not to talk about, and the individuals that they choose not to talk about at all. Because by the end of today's trial, it will be those details, those pieces of doubt, that will prevent the prosecution from meeting their burden in today's case, the highest burden in our justice system. Before you hear Ms. Sloan's side of the story, the prosecution will present to you two witnesses, Officer Taylor Wise and Duke Remington. Officer Wise was the officer that was called to the scene after the burglary. And you'll quickly notice that she won't be able to tell you very much because she didn't see very much with her own eyes. Except for one thing. She will tell you that as a part of her investigation, she went and spoke with Ms. Sloan's ex-girlfriend, Coco Remington. She noticed Ms. Remington was wearing a very familiar piece of jewelry on her finger. She asked about that. She even got a warrant to collect that familiar-looking ring. But by the time she tried to execute that warrant, Ms. Remington was gone, quit her job, left her apartment, and disappeared. Officer Wise will tell you today, she did not try to contact Ms. Remington and did not make any efforts in trying to find her or that ring again. You'll also hear from Duke Remington, Miss Remington's sister and a ranch hand that used to work for Miss Sloan. Duke Remington won't be able to tell you very much either, except he will tell you he was aware that before the burglary, the security lights around the house weren't working as they normally did. He'll tell you that her shoe size matches the shoes, the footprints that were found, both inside and outside of the house after the burglary. And he'll tell you the reason that he is here today. Because the prosecution told him if he testifies truthfully, they'll recommend his probation from his conviction be terminated. Now, we as the defense do not have to put on a case for you today. You must remember, throughout this whole trial, Ms. Sloan has a presumption of innocence and has no burden to prove anything at all today. However, we will present 2 witnesses to you to fill in the blanks of the prosecution's story. Explain what they did not explain. You'll first hear from Ms. Terry Teo, Ms. Sloan's loyal caretaker of 17 years. Ms. Teo will talk about the relationship and her duties on the ranch, how she knows how the house operates, and why everything that went wrong that led to Ms. Sloan's indictment was just a series of unfortunate events, coincidences that went wrong. And if she so chooses, you'll hear from the defendant, Ms. Sloan herself. Ms. Sloan will talk to you about the truth regarding her financial situation. And she'll talk to you about her relationship with Ms. Coco Remington, her ex-girlfriend. She'll tell you about how that relationship ended, and how in the very last conversation she had with Ms. Remington, it ended in a threat from Ms. Remington to Ms. Sloan. She will make it clear to you that everything that occurred before the burglary and after the burglary were simply crippling coincidences for Ms. Sloan. Now, at the end of the day, my co-counsel will stand up and he will talk to you about the law. He'll walk you through your jury instructions and help you understand the important task in front of you today. Before he does that, during this trial, remember to pay attention to the details in between the coincidences. Because coincidences, even crippling ones, are not conclusive.
Just one moment, please. People may call their first witness.
Yes, Your Honor. The people call Detective Taylor Weiss.
Right hand. Do you solemnly swear or affirm that the testimony that you're about to provide will be the truth, the whole truth, and nothing but the truth?
I do.
Counsel, you're welcome to inquire.
Good evening, Detective Weiss. Will you please introduce yourself to our jury and spell your last name for our court reporter?
Of course. My name is Detective Taylor Wise. Wise spelled W-I-S-E.
Detective Weiss, why are you here today?
I am the lead detective on today's case.
Can you help our jury understand a little bit about what a detective does?
Sure. So as a detective, I do many things related to crime investigation. I'll go to the scene, assist the evidence technicians in gathering and monitoring evidence collections, as well as conduct interviews and examine reports when necessary.
And where are you employed as a detective?
I'm employed with the Bear County Sheriff's Department.
And how long have you been with the Bear County Sheriff's Department?
I've been there for almost 15 years now.
Do you work in any specific division of the Sheriff's Department?
I do. I'm assigned to the Crimes Against Property Division. I've been there for the last 4 years.
Can you help us understand what a crime against property is?
Sure. So it can include a bunch of different things, really. Burglary, vandalism, theft, arson, things of that nature.
And when did you first become involved in the case concerning Dennis Sloan?
I first became involved in this case on October 29th when Ms. Sloan called our office to report an alleged break-in at her residence.
And what did you do after you received this call?
I called Ms. Sloan myself.
And what did Ms. Sloan tell you?
When I called Ms. Sloan, I told her that I would be bringing some evidence technicians out to the house and we would be there to investigate soon.
And what is an evidence technician?
Evidence technicians are kind of the forensic investigators involved with police work. They will gather...
Objection, Your Honor. 701, improper testimony from the lay witness.
Response?
Yes, Your Honor. The witness was not giving an opinion. I believe 701 is in reference to improper opinion testimony by a lay witness. Rather, the detective was merely describing what an evidence technician does, and she works with evidence technicians at the Sheriff's Department.
Thank you. The objection is overruled. You may answer the question. Complete your answer.
Detective, what is an evidence technician?
Evidence technicians are our forensic investigators. They will gather evidence, process evidence, things of the forensic nature.
And did evidence technicians go to Ms. Sloan's home?
They did.
Did they arrive before you, after you?
They arrived before I got there. I got there after they did.
And before you got there, were they able to start processing evidence at Ms. Sloan's home?
No, they weren't. Ms. Sloan requested that they wait until I get there to start processing.
Okay. And in your experience as a detective, specifically within the Property Crimes Division, is that a common request?
No, I found it a little unusual. In my experience, typically victims of crimes want the evidence technicians to get in and out as soon as possible.
And where is Ms. Sloan's home?
It's located in Bear County.
And when you arrived to Ms. Sloan's home on the 29th, what did you see?
When I first got there, I was outside of the home. When I was outside, I saw some footprints. Some were in the flower bed outside of the home. Some were also on the patio in the rear of the home.
And were you able to go inside of Ms. Sloan's home?
Yes, I was.
Well, what did you see once you were inside?
When I was inside the home, I saw some broken picture frames.
Were all the picture frames in Ms. Sloan's home broken?
No, only pictures of Miss Sloan's ex-wife, and their daughter were broken. Photos of the daughter by herself weren't broken.
And did you have a chance to speak with Ms. Sloan?
I did.
Did you speak with her in person?
Yes, I did.
And do you recognize Ms. Sloan in the courtroom here today?
Yes, I did.
And what is she wearing?
She's wearing a green blazer.
Let the record reflect that Detective Taylor Weiss has identified the defendant, Dennis Sloan, subject to cross.
Subject to cross and shall so.
Did Dennis Sloan tell you whether anything in her home was missing?
Yes, she told me that some jewelry was missing out of her safe.
And was she able to provide you with any photos of that allegedly missing jewelry?
Yes, she gave me some photos of that allegedly missing jewelry.
Your Honor, let the record reflect that I'm showing opposing counsel what's been marked as Exhibit B. Permission to approach witness?
You may.
Detective, would you take a look at the photos I just handed you?
Certainly.
And what are these?
These are the photos of the allegedly missing jewelry that Miss Sloan provided to me.
And are they in the same condition as they were when they were provided to you by Ms. Sloan?
They are.
Your Honor, at this time, we move to admit Exhibit B into evidence.
Any objection with one
No objection, Your Honor.
exhibit? Which exhibit?
Exhibit B, Your Honor.
Is admitted.
Your Honor, a moment to set up a demonstrative.
Please.
Detective Weiss, what is this?
That is a larger picture of the jewelry that was allegedly missing.
Are there any changes from those pictures to this one?
No, they're not.
Your Honor, permission to preserve for closing arguments
Of course.
and permission to retrieve.
You may.
And Your Honor, permission to publish Exhibit B to the jury.
You may.
Detective, did Dennis Sloan tell you where she kept this jewelry?
Yes, she told me that the jewelry was kept in a safe inside of her den.
And did she tell you whether or not the safe was locked?
She couldn't remember whether she locked the safe.
And how did that information strike you in the context of the pictures of jewelry she'd shown you?
I found that a little odd considering how nice that jewelry seemed to me.
Objection, Your Honor, relevance?
Well, the objection is just a moment late, so the testimony is already out. You want to respond briefly?
Yes, Your Honor. We believe that this goes to Ms. Sloan's behavior the day of the alleged break and the way that she was keeping her jewelry and whether or not it was safely maintained. goes both to whether or not a burglary actually occurred and whether or not Ms. Sloan was safeguarding her jewelry as a reasonable person would.
The relevance objection is overruled.
You may continue.
And did Dennis Sloan tell you whether or not her home had an alarm system?
Yes, her home did have an alarm system.
And did she tell you, did it go off the previous evening?
No, the alarm system did not go off because Dennis Sloan did not turn it on that evening.
Did she tell you why she didn't turn it on that evening?
She claimed that she thought a maid service was coming, and so she didn't turn it on.
And the previous evening, did Dennis Sloan see or hear anything?
No, she didn't see or hear anything. She wasn't there that evening.
Objection, Your Honor, speculation.
Response?
Yes, Your Honor, we can lay foundation as to how Detective Weiss knows that she wasn't home that evening and make an offer of proof.
Please.
If allowed to testify, Detective Weiss will explain that it was Dennis Sloan who told Detective Weiss that she was not home.
So I'll sustain the objection subject to additional foundation, and we'll imagine that all of this took place at the bench, so please proceed.
Your Honor, permission to strike the witness's previous response.
I'll strike the previous testimony. You can try again. Go ahead. Thank you.
So, did Dennis Sloan tell you about her whereabouts the evening prior to October 29th?
Yes, Dennis Sloan told me that she was not home on the night of October 28th because she had gone to New York to go to some charity ball and stayed at the Ritz that night.
Okay. And what night did Dennis Sloan tell you she left town?
She told me that she left on the morning of October 28th.
And what day did she tell you she returned?
She told me she returned on the morning of October 29th.
Detective Weiss, would it be helpful at all for you in giving your testimony to the jury today to make a timeline?
Yes, it would.
Your Honor, permission to set up a demonstrative exhibit with the witness so she can explain her testimony more fully?
Any objection?
Yes, Your Honor, cumulative and 403.
That objection is overruled. You may continue.
May I approach the witness?
Yes.
Detective Weiss, will you add the days that you just spoke about to your timeline?
Certainly. Drawing straight lines is not part of that component.
Thank you, Detective. Detective Weiss, did you conduct any interviews as a part of your investigation?
I did.
And did you speak with Terry Tayo?
Yes, I did.
And who is Terry Tayo?
Terry Tyler is the caretaker of Miss Sloan's ranch.
And why did you want to speak with her?
I wanted to speak with her because as the caretaker, I assumed that she might be familiar with the property, might have some valuable information that I could learn about the property and about that evening itself.
And when you saw Ms. Tayo, did you notice anything about her?
I did. I noticed that she was wearing some work boots, and the sole pattern looked similar to the footprints that we had seen outside the home.
And can you remind us what you saw regarding the footprints outside of Ms. Sloan's home?
Sure. So there were footprints outside the home. Some were in the flower planting bed. Some were on the patio itself at the rear of the home.
And did you speak with Coco Remington?
Yes, I did.
And who is Coco Remington?
Coco Remington is Miss Sloan's ex.
Objection, Your Honor, knowledge based on hearsay.
Lack of foundation is what I'm hearing. Response?
Yes, Your Honor. And Detective Weiss is the lead detective on this case. She spoke with Ms. Sloan, and Ms. Sloan did bring Coco, or may I make an offer of proof?
Well, I'll sustain the objection at this point. You're welcome to lay additional foundation. There's nothing to strike, so you're welcome to proceed.
Yes, Your Honor. When you were at Ms. Sloan's home, Did she mention if she had dated anyone recently?
Yes, she mentioned that she had previously dated Coco Remington, although they had recently broken up, and she was not her ex-girlfriend.
And did you speak with Ms. Remington?
Yes, I did.
And why did you want to speak with her?
I wanted to speak with her because as Miss Sloan's ex-girlfriend, I assumed that she also might be familiar with the property. I wanted to see if she had any sort of information that might be useful to my investigation.
And did she have any information that was useful into your investigation of October 28th?
No, not particularly.
And when you saw Ms. Remington, Ms. Coco Remington specifically, did you notice anything about her?
I did. I noticed that she was wearing a ring that looked similar to one of the rings that had been stolen, but I had no legal basis to collect the ring at that point.
Did you ever require a legal basis to obtain that ring?
I did. 2 days later, I did obtain a warrant. However, when I went to go serve it on her, she was gone.
And are you concerned about Ms. Remington's whereabouts now?
No, I'm not.
Why aren't you concerned?
I'm not convinced that she had anything to do with this.
Objection, Your Honor, 701, improper testimony.
Response?
Yes, Your Honor. This testimony is based on Detective Weiss's rational perceptions. We will lay further foundation about the other evidence that Detective Weiss uncovered, all of which forms Detective Weiss's conclusion that she does not need to be concerned about Ms. Remington's whereabouts.
The objection sustained. The jury's disregard the last statement, stricken from the record.
Yes, Your Honor. Did you ever speak with Duke Remington?
Yes, I did.
And did Duke Remington reveal any helpful information for your investigation?
I learned that he was not.
Objection, Your Honor, knowledge based on hearsay.
Overruled to the moment. You want to renew your objection. Let's proceed.
I learned that he was not at the ranch on the night of October 28th. He was at the Dewdrop Inn all night.
Objection, Your Honor, knowledge based on hearsay.
Response?
Yes, Your Honor. This time we are not bringing in this information for its truth, but rather for its effect on the listener. We will establish that the conversations that Ms. Sloan had with Ms. Remington had a substantial effect on the direction that her investigation took.
Brief rebuttal?
Yes, Your Honor, pursuant to Rule 701, insofar as this witness is not an expert, any effect on the listener knowing that Duke Remington had an alibi is irrelevant because any further effect requires the witness being an expert to actually conduct this investigation and use that information to further act on.
The objection's overruled. You're welcome to continue.
Detective Weiss, did speaking with Ms. Duke Remington have an effect on your investigation?
Yes, after I learned that she was not at the ranch that night, I no longer considered her a suspect in my investigation.
And were you able to confirm that she was not at the ranch that night?
I was able to confirm that.
Detective Weiss, did you learn anything about Ms. Sloan's financial background prior to the events of October 2021?
Yes, I did. I learned several things about her financial background.
And what did you learn?
I learned that she was somewhere around
Objection, Your
325.
Honor, knowledge based on hearsay.
Response?
Yes, Your Honor. These are facts that Detective Weiss learned during the course of her investigation. If I may be candid, we are not able to lay foundation as to specifically how Detective Weiss obtained these pieces of information. However, these pieces of information are corroborated by the prior trial testimony of the defendant, Dennis Sloan, and therefore should be admitted.
Brief rebuttal?
Yes, Your Honor, pursuant to 804, the exception we believe the prosecution is currently attempting to use, the first part of 804 requires the witness to be unavailable. It's a 5-step test to determine whether or not a witness is unavailable, and we believe that the prosecution doesn't satisfy any of them. Additionally, in part B of the exception, it requires that the witness had knowledge of the actual prior testimony. We don't know whether this witness was at the prior trial or was an advisory witness or even knew any of the details of that prior trial as first-hand knowledge.
Call for proof as to unavailability.
Yes, Your Honor. As to unavailability, it's the prior trial testimony of the defendant, Dennis Sloan. We are required to presume that the defendant, Dennis Sloan, is unavailable to us to call as a witness, as she has a privilege, which makes her unavailable as per 804-81.
Any additional response?
Regarding which part of the objection?
It's okay. The objection's overruled. Good exchange. Let's continue.
Detective Weiss, what did you learn about Ms. Sloan's prior financial situation?
I learned that she was about $325,000 behind on her mortgage payments, and the bank was intending to start foreclosure proceedings.
I'm showing opposing counsel what's been marked as Exhibit A. Permission to approach?
Please.
Detective Weiss, what is this?
These are pictures of Miss Sloan's branch.
And do you recognize these pictures?
I do recognize these pictures.
How do you recognize these pictures?
I recognize them because they were published in a magazine that deals with expensive homes that are for sale.
Your Honor, at this time we move to Exhibit A into evidence.
Any objection to here?
No objections are part here.
There was a stipulation of admissibility earlier. Are we still jumping through these hoops? Or?
Your Honor, we stipulated them as admissible with proper foundation laid, but if you'd like us to just move straight forward to admitting them.
Well, it's good for you to do this.
So, with hearing no objection, A is admitted, so A and B are in.
You're welcome to continue.
Detective Weiss, is this the home that Dennis Sloan was facing foreclosure on?
Yes, this is the home that he was facing foreclosure on.
Was this the home that Dennis Sloan was $325,000 behind on mortgage payments on?
Yes, this is the home that he was $325,000 behind on the mortgage payments.
And did you learn whether this home was for sale?
I did. This home was put up for sale in June. It had not sold yet, as far as I was aware.
Detective Weiss, would you mind adding that event to your timeline?
Sure. May I?
Please.
Thank you.
Thank you.
Detective, did you ever have any conversations with Ms. Sloan about any financial transactions she made?
Yes.
Objection, Your Honor, hearsay.
Response?
Yes, Your Honor. The conversation which Detective Weiss will speak to will be with the defendant, Dennis Sloan, and this comes in under 801D2, closing price statement.
Overruled. Continue.
Again, Detective Weiss, did you ever have any conversations with Dennis Sloan about any financial transactions she made?
Yes, I talked to Ms. Sloan about a $25,000 withdrawal that she made on October 29th.
And did you ask her why she made this withdrawal?
I did. She told me it was for living expenses, and then when I asked further, she told me to talk to her lawyer.
And what day did you say this transaction was made on?
I believe it was October 29th.
Would you mind adding that to your timeline?
Certainly.
Please.
Maybe.
Yeah, you don't need to keep asking. It's fine.
Yeah, Your Honor. Did you learn anything else about Ms. Sloan's behavior around the time of late October 2021?
Yes, I also learned that Ms. Sloan shipped a package to Switzerland to her safety deposit box in a Swiss bank.
And did you ever learn what was inside of that box?
No, I was never able to learn what was inside of that box. The Swiss have pretty strict banking laws.
And did you ever learn if Ms. Sloan took out any insurance on that box?
Yes, Ms. Sloan insured that package for $385.
Objection, Your Honor, hearsay.
Response?
Yes, Your Honor. Detective Weiss learned this fact over the course of her investigation, and then this fact was corroborated at the prior trial of Dennis Sloan.
Learn from whom?
we, to be candid, Your Honor, we're not able to lay foundation as to that fact.
Okay, the objection is sustained.
Your Honor, the defense moves to strike.
That request is granted, jury will disregard, you're welcome to continue.
Detective Weiss, did you have any conversations with anyone from Lone Star State Insurance Company?
Yes, I had a conversation with Susan Rockford of Lone Star State Insurance Company in November.
And did you ever speak with Ms. Rockford in person?
Yes, I met with Ms. Rockford in November.
And did she bring any paperwork with her?
Objection, Your Honor, knowledge based on hearsay.
Not yet, overruled, you're welcome to continue.
Again, Detective Weiss, did she bring any paperwork with her?
Yes, she did. She brought some paperwork with her.
I'm showing opposing counsel. It's marked as Exhibit C. Permission to approach.
Please.
Detective Weiss, what is this?
This is the paperwork that Susan Rockford provided me. It's the proof of loss form that Dennis Sloan submitted to Lone Star State Insurance.
And is this the same proof of loss form that she gave to you on that day?
Yes, it is.
Any alterations or changes?
No, there are no alterations or changes.
Remember, this time we moved to admit Exhibit C into evidence.
Any objection to C?
No objections, Your Honor.
C is admitted.
Detective Weiss, can you help us understand what is a proof of loss form?
Sure. So a proof of loss form is what somebody files when they're trying to collect insurance money on something that they're claiming has been lost or stolen or something of that sort.
And who submitted this form?
Dennis Sloan submitted this form.
And does that mean that Dennis Sloan is requesting a payout form or something?
Yes, Dennis Sloan is requesting a payout for 6 items of jewelry.
And are they these same 6 items?
I believe so.
And are the values of those items listed on that form?
Yes, the individual values are listed on this form.
And roughly what do those values add up to?
Roughly $380,900.
And what is Dennis Sloan claiming happened to these pieces of jewelry?
She is claiming that she left to go out of town on October 28th. When she returned, that she discovered that someone had broken into the house and stolen jewelry from the safe in her tent.
And on what day did Ms. Sloan submit this form?
This was submitted and notarized on November 4th.
Detective, would you mind adding that date to your timeline?
Sure.
And Detective, would you mind adding the amount of the insurance claim to your timeline?
Certainly.
Detective, could you take a look at your timeline and see if there's anything else that you would like to add to it?
Objection, Your Honor, leading the witness.
Overruled.
Not at this time.
Your Honor, may we preserve the timeline for closing arguments?
You may.
No further questions at this time.
Cross-examination.
Yes, Your Honor.
Permission to retreat.
Please.
Opposing counsel. Mr. Weiss.
Oh, pardon me.
Permission to proceed, Your Honor.
You may.
Permission to remove plain prosecution's demonstrative.
You're welcome to do so.
Permission to remove it.
Yeah.
Right, thank you, Your Honor.
That's right, these are not the droids you're looking for. Go ahead, Evan.
Good evening, Detective Wise.
Good evening.
I'd like to start by talking about those pictures you were talking about during direct examination.
Sure.
You mentioned that you saw the damaged pictures.
The picture frames.
Yes, Detective Wise.
Yes, I was aware that the picture frames had been broken.
You didn't actually see the pictures, did you, Detective Wise?
No, I didn't see them myself.
You're a professional detective, right?
Yes, I'd say so.
And you've been a detective for almost 15 years.
Yes.
You're currently with the Crimes Against Property Division,
Yes.
and you've been with that division for about 4 years.
Yes.
It's your job to properly investigate crime scenes.
Yes.
It's your job to investigate every potential suspect.
Every potential suspect that I think is worth investigating, yes.
It's your job to investigate every piece of relevant evidence.
Yes, every piece of relevant evidence.
I'd like to start with your involvement in this case.
Sure.
You're the lead detective in a case involving an alleged burglary of Dennis Sloan's residence.
Yes.
You received a call from Miss Sloan on October 29th, 2021.
That's correct.
You were assigned to investigate the case.
Yes.
You've never dealt with Miss Sloan before, have you?
No, I did not know Ms. Sloan personally before this investigation.
In your opinion, Miss Sloan is a very prominent member of Armadillo Society.
Sure.
Let's start with what you did during your investigation. You arrived at Miss Sloan's house in the early afternoon on October 29th, 2021.
Yes.
You weren't the first to arrive at the house.
No, my evidence technicians got there before I did.
When you got there, you spoke to the technicians.
Yes.
The technicians showed you several sets of footprints.
Yes.
The technicians also showed you broken panes of glass.
Yes.
I'd like to focus on the technicians' findings. We'll start with the footprints. Some of the footprints were in the dirt in some planting beds.
Yes.
You discovered that the footprints in the dirt matched the footprints of a pair of work boots.
Yes.
Terry Teo, Miss Sloan's caretaker, owns a pair of those boots.
Yes.
You didn't investigate if any other boots can make that footprint, did you?
No.
You didn't investigate if anyone else had that type of work boot, did you?
No, I had a match.
So because you had the match, you felt like you didn't need to see if anyone else had that boot?
I had a match.
I'm sorry, is that a no?
That's correct. I didn't feel I needed to investigate further once I found a match.
If we could just stick to yes or no answers, that'd be great, thank you. Some more footprints were found in the flagstone patio at the back of the house.
Yes.
You couldn't match that footprint to the boot, could you?
That footprint in particular, I don't think so.
The size of that footprint was approximately the same as the size of the footprint of the planting bed, though.
I think so.
You think so, Detective?
That sounds right.
You weren't able to determine if the footprints were exactly the same size, though, were you?
No.
You didn't investigate anyone with that same size footprint, did you?
No.
Now that we talked about the footprints, let's move on to the broken panes of glass. The broken glass was in the French door leading to the flagstone patio.
Yes.
The technicians were in the process of trying to obtain fingerprints from the French doors.
Yes.
You later learned whose fingerprints were on the doors.
Yes.
You later learned Duke Remington's fingerprints were on the doors.
Along with some others.
You later learned Miss Sloan's fingerprints were on the doors.
Yes.
You also learned Terry Teo's fingerprints were on the doors.
That's correct.
You also learned other ranch hands' fingerprints were on the doors.
Yes.
But Detective, during your investigation, you didn't know whose fingerprints were on the glass panes, did you?
When you first start an investigation, you don't know whose fingerprints are whose until you process them.
At the time you gave your deposition, you didn't know whose fingerprints were on those glass panes, did you?
No.
That's because during your investigation, you didn't feel the need to wait for the results of that fingerprint analysis, did you?
I don't set the dates that depositions are taken.
Detective, the deposition was taken after you'd concluded your investigation, wasn't it?
That sounds right.
And Detective, you swore you'd modify your deposition if anything came up in the future, didn't you?
Yes.
So now you've reached the house, and you've talked to the technicians. Let's go from there. You eventually went inside the house?
Yes.
When you were inside, you talked to Miss Sloan?
Yes.
When you were there, she gave you pictures of the missing jewels.
Yes.
Let's talk about those jewels. You believe Miss Sloan claimed $386,975 for the jewelry?
I believe that's what I said in my deposition, but there's no total
On the proof of loss form, I'm a detective, I'm not a mathematician. It's a lot of numbers. It's around $380,900.
Detective, you didn't modify your deposition when you later learned of the right number, did you?
No, I didn't.
The jewelry was in a safe, Detective?
Yes, that was my understanding.
You didn't investigate the safe for fingerprints, did you?
No.
In fact, Detective, you didn't even see the safe, did you?
Not that I recall.
You didn't feel the need to see the safe where jewelry was stolen?
I was talking to someone who I thought at the time was a victim of a crime. She told me that the safe wasn't damaged.
Over the course of your investigation, you rely on the words of witnesses
Yes,
over your own investigative skills?
I rely on the words of witnesses along with my own investigative skills. That's part of my investigation.
Yet your skills you didn't find the need to investigate the safe through your skills, Detective?
At that point in time, no.
At this point in your investigation, you knew that Miss Sloan had several employees.
Yes.
You didn't check if any of them knew the combination to the safe, did you?
I knew that several people had access to the safe, and it was possible that several people could have had the combination.
Is that a no, Detective?
Can you re-ask the question?
Of course. You didn't check if any other employees knew about the combination.
I didn't talk to any other employees personally. I took Miss Sloan's word for it.
So during the course of your investigation, you didn't find the need to talk to other employees at the ranch in which a burglary was reported, Detective?
Objection, asked and answered.
Overruled.
Let me ask that one more time, Detective. During the course of your investigation, you didn't find the need to talk to other employees at a ranch in which a burglary was reported,
I did. I talked to Duke Remington and Terry Tayo.
besides Duke Remington and Terry Tayo, Detective.
No.
In fact, you didn't check if anyone besides Duke Remington and Terry Tayo actually knew about the safe at all.
I knew the ex-wife also knew about the safe.
And you didn't talk to her, did you, Detective?
No.
In fact, Detective, besides Duke Remington and Terry Tayo, you can't even name a single other employee, can you?
No, it's a pretty big ranch.
It's a pretty big ranch that you didn't even look to talk to anyone else to learn anyone's name, Detective?
No.
Let's talk about Coco Remington. Coco Remington is Miss Sloan's ex-girlfriend.
Yes.
You didn't ask Coco Remington if she knew about the safe, did you?
No.
You didn't ask Coco Remington if she knew about the safe's combination, did you?
No, but Miss Sloan had indicated to me something along that nature.
I'm sorry, Detective. I know you want to talk about what Miss Sloan told you, but I'm just asking about your investigation. So let me ask one more time. You didn't ask Coco Remington if she knew the safe's combination.
No, I didn't ask for that.
You noticed Coco Remington was wearing a ring.
Yes, I did.
The ring looked like one of the rings that had been stolen.
Yes.
You obtained a warrant to collect the ring.
Yes.
You waited 2 days to obtain the warrant.
2 days.
Is that a yes, Detective?
Yes.
By the time you obtained the warrant, Coco Remington was gone.
Yes.
You didn't try to track her down, did you?
I haven't been able to find her since.
You didn't search in other counties for her.
No.
You didn't try to find her through video cameras across the town.
Video cameras across the town?
Security cameras, Detective.
No.
You didn't try to locate her car, did you, Detective?
I don't even recall if she owned her car.
You didn't try to check if she was using her credit cards anywhere, did you, Detective?
I don't recall if she even had credit cards.
I want to talk to you about who you did investigate. You talked to Miss Tia.
Yes.
You talked to Miss Remington.
Yes.
Sorry, Duke Remington.
Yes.
You talked to Coco Remington.
Yes.
Now I'd like to talk about who you didn't investigate. You didn't talk to any of Miss Sloan's other longtime employees.
No.
You didn't talk to Miss Sloan's ex-wife.
No.
Detective Wise, you didn't talk to anyone else at all, did you?
Besides Coco Remington, Duke Remington, Terry Tayo, and Miss Sloan, no.
Nothing further.
Redirect.
Yes, Your Honor, briefly. Detective Weiss, did you speak with Coco Remington?
Yes, I did.
And after that conversation, did you want to speak with her again?
Yes. I did. I tried to serve that warrant 2 days later, but she was gone.
And are you worried about Ms. Remington's whereabouts now?
No, I'm not.
Why aren't you worried about her whereabouts?
I don't believe she had anything to do with this.
And did you speak with Duke Remington?
Yes, I did.
And at this point in time, do you believe that Duke Remington is a suspect with regards to the missing jewelry?
No, he was
Objection, Your Honor, 701, improper testimony.
Response?
Yes, Your Honor. At this time, my question was merely as to whether or not she considered him a suspect.
The objection sustained. Any additional redirect?
Just one moment, Your Honor.
Yes.
No further questions, Your Honor.
All right, and give us just one moment, please. Prosecution, well, you're welcome to step down. Thank you. And the prosecution may call its next witness.
Yes, Your Honor, the prosecution calls Duke Remington to the stand.
Please raise your right hand. I've already done it. Do you solemnly swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please be seated. Counsel, you're welcome to inquire.
Good evening, Ms. Remington. Will you please state your name and spell your last for the court record?
Yes, my name is Duke Remington. Last is spelled R-E-M-I-N-G-T-O-N.
Ms. Remington, before we kind of jump in, I want to talk a little bit about your background. Are you currently on probation?
I am on probation as of right now.
And why are you on probation?
Well, I recently got out of prison, so I'm serving out the rest of my probation. I've got about 5 years left.
Is there anything you would like to disclose about your testimony today to the members of the jury?
Yes, so I do have an agreement with the district attorney's office that if I am to testify truthfully today, which I'm planning on doing, they may recommend that the rest of my probation be terminated.
Why have you, why are you testifying today?
Well, I chose to testify today because I knew that I had some facts relating to this case and I wanted to make sure bring them to light, if you will.
I want to talk now about your relationship with the defendant, Ms. Sloan. How do you know Ms. Sloan?
I actually used to be employed for Ms. Sloan.
How long did you work for her?
Oh, a good 8 months, I'd say.
And how did you come to work for her?
I started working for Ms. Sloan after I got out of prison. I knew her through my sister, Coco, and Ms. Sloan was generous enough to give me a fresh start in life.
How did your sister Coco know the defendant?
My sister, Coco, used to be dating the defendant.
I want to talk now about your work on the ranch. What were you hired to do?
I was hired as a ranch hand. I didn't really have any ranching experience, but like I said, Ms. Sloan was very generous and allowed me to sort of learn the ropes.
And what did your job entail?
Well, I did some cattle management, I worked with other animals, I did land maintenance around the house, things like that.
Do you currently work for Ms. Sloan?
No, not anymore.
Why not?
It's embarrassing to admit it, but I was fired.
What day was that?
I was fired, I believe, on October 31st of 2021.
I want to talk about the house, Ms. Sloan's house on the ranch. Did your work take you around the house?
Yeah, I was familiar with the house. I mostly worked outside, but I had seen it, I had worked around it, I was there.
Your Honors, I am showing opposing counsel. It has been admitted and marked as Exhibit A. Permission to charge.
Okay.
Ms. Sloan, do you recognize this?
I do.
How do you recognize it?
This looks to be the outside of Miss Sloan's house, her front yard, and then her terrace area.
I want to focus our questions now on the security around the house. What kind of security around the house did you notice?
I was aware of one security feature. There was a set of lights along the side of the house that were motion activated. They were supposed to light up when you went past.
How do you know that that's what they did?
Well, actually a couple of nights before the break-in, I walked past those lights in the evening and they lit up.
Did you notice anything unusual occurring with those lights after that point?
Yeah, later I did notice my coworker Terry up on a ladder, working around on the roof where those lights were, messing with them. I'm not totally sure what she was doing.
Let's pause for a moment. Who is Terry?
That's Terry Tayo. She's my coworker, or she was when I worked for Miss Sloan.
How long did you work with Miss Tayo?
Miss Tayo had worked at Miss Sloan's house for a long time.
Objection. Non-responsive.
Let me re-ask that question.
You don't need to.
Okay. And Miss Remington, what did Miss Tayo do in her job?
It's my understanding that Miss Tayo was Miss Sloan's caretaker. So that generally means I would say that she fixed things around the house. She just did any orders that Miss Sloan told her to do.
All right, so kind of coming back to the lights and security, after you saw Miss Tayo messing with the lights before the alleged break-in, did you notice anything about those lights?
Yeah, I walked past shortly after that and the lights weren't lighting up anymore.
Did you ask Miss Tayo about this?
I did, I thought so.
And what did she say?
Objection. Hearsay.
Response?
Yes, Your Honor. Under 801 D2D, any response by Ms. Tayo comes in as the statement of a agent. Alternatively, and in addition, this statement could come in under 801 D2E as a statement of a co-conspirator.
Brief rebuttal.
Yes, Your Honor. Not any statement comes in under Rule 801 D2D. Only statements made within Ms. Tayo's capacity as a caretaker. Here, we don't have foundation to know what the response to this statement. If I may constructively approach and make an offer of proof as to what the statement will be.
Please.
I believe the statement is mind your own business or something along those lines, and given that it has nothing to do in the course of her job. Furthermore, I can respond to 801 D2E as well if you.
Go ahead.
Under 801 D2E, we have no indication at this point in time about whether or not Ms. Tayo is a co-conspirator in this case. There's been no foundation laid as to that point. Offering this statement does not make that as an element of this case. Furthermore, there is no conspiracy charge that we are dealing with today. The statements offered by Ms. Tayo are under 801 inadmissible hearsay being offered for their truth. As such, we don't have the foundation that they require in order to be party opponent statements under 801 D2D or 801 D2E.
Any objections to staying?
Your Honor, may I make an offer of proof as to the agent exception?
For the purpose of the record on appeal, if necessary.
Yes, Your Honor. We have established that Ms. Tayo Ms. Remington worked with Ms. Tayo for 8 months. She knew that her duties involved fixing and maintaining things in and around the house, and that she followed Ms. Sloan's orders. Therefore, any statement that Ms. Tayo would make about those lights and that what she did to them would be within the scope of her employment in that relationship with Ms. Sloan.
All right, fair points all. You have the court's ruling, you're welcome to proceed.
I want to talk about, Ms. Remington, the October 28th, 2021. What were you up to that evening?
That evening, I was at the Dewdrop Inn, which is a local bar.
How long were you there?
Oh, I was there all night.
What were you doing at the Dewdrop Inn?
The average things you do at a bar. I was hanging out with friends. We were playing pool.
Can anyone corroborate that you were there?
Yeah, I was there with a pretty big group of friends, and I know the owner, so he could tell you I was there.
What was the owner's name?
His name was Clint.
And the next day, October 29th, what did you do that day?
Well, I went to work in the morning, and when I showed up, the police were there.
Okay. And did you have any interactions with anybody that stood out to you following that, your arrival at work?
Yeah, I had some interactions with Terry. First one that I can think of is I saw Terry come out of the house with all the hubbub that was going on and went and put a small box into a car and went back inside.
Did you, what did you do next?
Well, it was one of Miss Sloan's cars, actually. I went and peeked through the window.
What did you see when you looked inside?
I saw a box. It was just a little box that had shipping label on it.
Did you happen to notice the shipping company?
Yeah, I did. I believe it's being shipped through DHL.
Did you happen to notice where the box was being shipped to?
Objection calls for hearsay.
Response.
Your Honor, an inscription is on a box as far as an address goes is not hearsay. It is not a out-of-court statement that is attempting to prove any sort of fact. It is simply a written act.
Why is it not?
Your Honor, generally speaking, when we write addresses on a postal cord, it's like on a piece of postage, it's like filling out a form, and the post office is just going to take it there. It is not a statement given to a specific person to prove the truth of any matter and contained within that address.
Rebuttal.
Your Honor, under 801, hearsay is any out-of-court statement offered for the truth. Here, the address that on this package, I believe, will be offered for the truth of where the package was sent. Presumably somebody wrote the address on the package, and the jury will hear that as the truth of where the package was sent. As such, it is being offered for its truth and is hearsay regardless of whether or not it is an address or any other type of statement.
Do we know whose statement it was, or ostensibly was?
Your Honor, if I may make an offer of proof, the box was ordered to be shipped by the defendant, Ms. Sloan, and therefore, even if it is, it could come in under 801D2A as non-hearsay, opposing statement.
And how are you going to get that linked in the chain?
Your Honor, we have the deposition of Ms. Terry Tayo, who is likely to testify today, and the defendant is likely to testify. We will corroborate from Ms. Tayo, who told her to ship that box and where to ship it to.
All right, the objections are overruled. Thank you.
Ms. Remington, did you happen to see where that box was being shipped to?
Yes, it said on the label that it was going to Switzerland.
When you saw that it was DHL, how did that strike you?
I thought that was interesting because in my capacity working for Ms. Sloan, I knew that she had a contract.
Objection, hearsay, and relevance.
Response.
Yes, Your Honor. We have laid a foundation that Ms. Remington has worked for 8 months at this point in and around the home. She would be aware of the comings and goings of a FedEx truck coming down towards the ranch in her experience. So it's a logical inference that she would know that FedEx normally services the Sloan Ranch.
Maybe a little tenuous, but I'll overrule the objection.
Why did that strike you as odd, Ms. Remington?
So, as I was saying, Ms. Sloan had a contract with FedEx, so pretty much everything that was sent out of the house went through FedEx. And I'd been at work that day, and I had already seen the FedEx truck come and go, so I was curious as to why the package hadn't been shipped out with them earlier in the day.
And what happened after you kind of peeked in and looked at the package?
Oh, Terry came out of the house and started yelling.
Did you have any other interactions with Ms. Tayo that kind of struck you as unusual?
Yeah, I did. Later, Terry actually drove up to the ranch in what appeared to me to be a brand new car.
Why did that strike you as odd?
Well, at least for me, working for Miss Sloan, I had just gotten a pretty significant pay cut. I know that I couldn't have afforded a brand new car at that point in time.
Did you ask Ms. Tayo about that?
Yeah, I brought it up.
And how did she respond?
Objection calls for hearsay.
Response.
Yes, Your Honor. As an offer of proof, if the defendant is allowed to testify, she will report Ms. Tayo told her that she got an inheritance from an aunt of $25,000, which is how she was able to purchase the car. We know that this statement was in fact untrue. Ms. Tayo did not get $25,000 from an aunt. In fact, Ms. Tayo did not have any family to speak of at all. An untrue statement, Your Honor, is not hearsay because it is not a statement offered to prove the truth of any matter, because there's no truth in that statement.
I like it. It's creative, but I'll sustain the objection.
Move to strike if there was any answer. Sure.
No, there was. To the extent there was, it's stricken.
Miss Remington, I want to talk about the day you were fired. Can you remind us of that date?
Yes, that was the 31st of October, 2021.
And how did that event occur?
Miss Sloan called me to her office. I had no idea what she could want. And I went in and she told me that she believed I had broken into her house and stolen something from her and that I was therefore fired.
How did you respond to that?
Oh, I was blindsided. I had no idea what led her to believe that I was ever I was ever in her house breaking in, stealing anything. It was very hurtful.
No further questions, Your Honor.
All right, cross-examination.
Yes, Your Honor. Good evening, Miss Remington. Let's begin by talking about your motivations for being here today.
That sounds good.
You have a prison record.
I do have.
You were convicted in dealing in stolen property.
That's true.
Objection, Your Honor. 403.
Response?
Your Honor, under 403, relevant evidence may only be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. Here, pursuant to Rule 609A1, this conviction, if we are outside the presence of the jury at this point,
Please.
this conviction occurred within 10 years, and given that Ms. Remington is not the defendant in this case, must be admitted subject to 403. Here, the line of questioning that I'm going down goes to show Ms. Remington's probation, why she is here, which I believe opposing counsel also opened the door to. Under 609, the entire conviction must be admitted, not just the fact that there was a conviction, but the actual conviction itself.
So, refresh my memory, 609 under the federal rules is actually a reverse 403 test, isn't it?
I believe the part that I am referring to is subject to 403. Later in 609, I believe it's 609 B or C, it is a reverse 403. However, because the witness is not the defendant, it is subject to 403, not reverse 403. If we were talking about the defendant, you are correct, it would be a reverse 403 in which the probative value must substantially outweigh prejudicial effect. Here we are talking about 403.
All right, rebuttal.
Yes, Your Honor. If the jury were to hear the name of this conviction, Your Honor, we believe that this would cause undue prejudice. They would confuse that it is unfair risk, substantial unfair risk of jury misuse, and that way they will confuse who is being accused of what here. And then we believe the defense will try to point blame and suspicion on Ms. Remington because of her prior past convictions. And, if we were going to talk about the conviction, Your Honor, I would request a limiting instruction as to its use, that it cannot be used to show any sort of propensity, as well as any sort of character evidence. Your Honor.
Very brief responses to the request for a limiting instruction.
Your Honor, again, I would say that because this witness is not the defendant, this must be admitted subject to 403. Here, the probative value substantially outweighs the prejudicial effect, and therefore the jury does deserve to hear this. Just because it's unfair doesn't mean it's unfairly prejudicial. Just because it's prejudicial doesn't mean it's unfair.
Specifically as to the request for limiting instruction to
Make sure that the jury doesn't use it for propensity.
Yes, Your Honor. Here, the conviction is for dealing in stolen property. I believe what the opposing counsel is concerned about is that they will confuse her to be the thief in this case. That is a different conviction. That is theft. Here, dealing in stolen property is a different conviction than theft. Therefore, there is no propensity argument that because she stole and once before, she did it again.
All right, so the objection's overruled. The request for limiting instruction is denied. We'll just leave it to argument. Yeah.
I will re-ask my question, Ms. Remington. You were convicted in dealing in stolen property.
That was true.
You got out early, though, due to gain time
Yes, 7 years instead of 10.
and prison overcrowding.
True.
You're still on probation today.
Yes, I have 5 years left.
You're testifying on behalf of the prosecution today.
That's true.
You also have an agreement with the state's attorney's office regarding your testimony today.
Yes, I do.
If you testify truthfully, they will recommend that your probation be terminated.
Yes, that's true.
Otherwise, you still have 5 more years of probation.
Yes.
So now that we know why you're here, let's begin by talking about your previous employment.
Okay.
You used to be a ranch hand for Miss Sloan,
Yes, for 8 months.
and you were hired by Miss Sloan because your sister Coco was dating her.
That's true.
You'd actually been in prison while your sister began dating Miss Sloan,
Correct.
and she hired you when you got out of prison.
Sure.
You were under the impression she hired you to help give you a fresh start.
I think so. That's my understanding.
This was despite your lack of experience as a ranch hand.
I knew how to ride a horse, but like I said, she let me learn the ropes.
Even so, you worked for Ms. Sloan for 8 months.
Yeah.
And during this time, your sister's relationship ended with Ms. Sloan.
Yes, in September of 2021, I did.
But you kept your job after that.
Of course, yes.
So now that we know about how you got your job, I want to talk about your responsibilities. In your 8 months working for Ms. Sloan, your responsibilities involved tending to the ranch.
True.
You wore the same boots as the rest of the ranch hands.
I believe so.
You wore a size 8 specifically.
I did.
And also back to your responsibilities, you had some familiarity with the property.
Yes, of course.
You knew how the house was run.
I had a general idea at least.
You were familiar with how the outdoor lights worked.
Yes,
You were aware that there was an alarm system.
I was aware of the alarm system, yes.
Okay. So now that we know how familiar you were with the property, I want to discuss your actions around the time of the burglary. Now, on direct examination, you mentioned that you saw Ms. Teo messing around with lights.
Yeah, up on the ladder on the roof.
And this was before the burglary happened.
2 nights before.
And after the lights weren't working,
The next day.
that's a yes.
Yes, that's a yes.
So before the burglary, you were aware that the security lights weren't working.
That's true.
Okay. These were motion sensor lights,
Yes.
so that means they wouldn't be triggered by motion if they weren't working?
Right, if they were turned off or broken, probably not.
Okay. So after the burglary, let's move to that point now. You were fired.
Yes.
After you were fired, you called your sister Coco.
Yeah, that same day.
So I'd like to talk about your sister now.
Okay.
When you called her, she sounded nervous on the phone.
Yeah, I would say so.
She was in a hurry to get off the phone.
It seemed like she was.
Okay. And this phone call happened the same day you were fired,
Yeah, it was later that evening.
October 31st, 2021.
Yes.
You didn't talk to your sister again after this.
No, I did not.
You did hear from her a couple of weeks later, though.
Yeah, by way of a postcard.
I'm now showing opposing counsel what has been pre-marked as Exhibit D, permission to approach for purposes of identification.
Yes. You may.
Mr. Remington, I just handed you what has been pre-marked as Exhibit D. You recognize Exhibit D?
I do.
This is the postcard that your sister sent you.
Yes, it is.
This postcard is in the same condition as when you first received it.
It looks to me.
That's her handwriting.
Yes, it is.
That's her signature.
Yes, it is.
At this point, defense moves to admit Exhibit D into evidence.
The people object to admitting Exhibit D to evidence, Your Honor.
You want to state your basis?
Yes, Your Honor, on 802 hearsay grounds as well as 403 unfair risk of jury misuse.
Response to the hearsay objection.
Yes, Your Honor, pursuant to Rule 801, hearsay is an out-of-court statement offered for the truth of the matter asserted. Here, this is pursuant to Rule 803.3, an exception to hearsay as a state of mind statement. If we may approach, and I may give an offer of proof as to the statement.
Please.
Your Honor, this statement, what it says on the postcard is, "Thank you for helping me get what was coming to me." This reveals a potential motive, intent, and plan given the rest of the evidence in this case. Taken in conduct with everything else that the jury will hear today, this statement does go to Ms. Coco Remington's state of mind. As such, regardless of her presence or absence in this courtroom, is a state of mind statement and falls under that hearsay exception.
All right, so the hearsay objection is overruled, and 403 objection is as well. I find it goes to rape, not admissibility. So D is in. You're welcome to continue.
Ms. Remington, this postcard that you received states, "Thanks for helping me get what was coming to me." Correct?
That's true.
Coco is signed underneath that statement, correct?
Correct.
You received this postcard after you were fired,
Yeah, a few weeks later, I think.
after your last conversation with your sister that evening.
Yes.
You moved to a new residence on November 1st.
True.
Your sister sent this postcard to your new residence.
She did.
So backing up a little bit, during that last conversation you had with your sister on October 31st, you didn't mention to her you were moving to a new address?
Maybe I did. I don't remember.
You didn't mention to her you were moving to a new address, correct?
I don't think so.
Is that a no?
I suppose so.
Is that
I
a
don't
no?
really remember.
Okay. No further questions.
proceed, Rick?
Yes, Your Honor. Ms. Remington, you mentioned you spoke to your sister after you were fired.
Right on the phone that night.
Okay, and did you, do you recall all of the content of that phone call?
No, like I mentioned, I don't remember if I told her my address or not.
I want to ask you whether when Mr. Sloan and when Ms. Sloan fired you, you had any indication that you had done a poor job at your work.
Oh no, I thought that Ms. Sloan was really happy to have my services. I didn't get any indication from her that anything was going wrong.
When you got out of prison, what was your plan for your life?
Objection, relevance?
Overall, my answer.
Well, my plan when I got out of prison was to, well, like I said, get a fresh start. That was part of what my job with Miss Sloan was all about, was to give myself a second chance and to make sure I did right by everybody from there on out.
And moving forward, since you've been let go from that job, what is your plan?
Just to continue on that path. It might not have worked out working for Miss Sloan, but that doesn't change any of the new convictions that I have.
No further questions, Your Honor.
So why don't we take 5? So I guess I'm safe in assuming there are no additional witnesses for the prosecution and, all right.
Yes, Your Honor.
So, okay. Prosecution rests, and so it's halftime.
All rise.
Okay.
All rise.
Yes. Found your call. Please be seated. Thank you. Okay. Are there any motions that we need to address at this time?
Yes, Your Honor. Pursuant to the Federal Rules of Criminal Procedure, Rule 29A, the defense moves for a judgment of acquittal. Considering all the evidence in the light most favorable to the opposing party, no reasonable jury can find for the prosecution. To summarize, the crime of insurance fraud contains 3 elements. First, a statement in support of an insurance claim. Next, the statement must have contained false or misleading information. And finally, the person who filed the statement must have intended to defraud their insurance company. Considering that the prosecution has rested their case in chief, they cannot meet the second and third elements based on what you've heard today. You've heard the testimonies of both Detective Wise and Duke Remington, and based on the investigation of Detective Wise, and more specifically the people Detective Wise did not investigate, as well as the actions of Duke Remington, we believe that it is impossible for the prosecution to meet the second and third elements of the charge.
Response?
Yes, Your Honor. The people have presented evidence for each of the elements of insurance fraud. By submitting Exhibit C, we established that the defendant, Dennis Sloan, submitted an insurance claim for payment from Lone Star State Insurance Company to meet elements 2 and 3, that Ms. Sloan knew that fact material to her claim was fraudulent and that she intended that fraud. We demonstrated that Ms. Sloan was undergoing severe financial distress at the time of the alleged burglary, that she took out a payment of $25,000 at that time, that she sent a package to a Swiss bank around that time, and that footprints and fingerprints matching her caretaker, Terry Tayo, were found around her home, and Terry Tayo was her potential co-conspirator. When viewed as a whole in the light most favorable to us, the people, this evidence does support a conclusion by a reasonable juror that the defendant is guilty beyond a reasonable doubt.
All right. Viewing the evidence in the light most favorable to the people, the defendant's Rule 29 motion is respectfully denied. Any other issues we need to address now?
No, Your Honor.
Your Honor.
All right. That's right. could all be eating right. So, does the defense plan to put on any evidence?
Yes, Your Honor. The defense requests to call Terry Teo to the stand.
All right. Good evening. Do you solemnly swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat. Counsel,
Permission to proceed, Your Honor.
please.
Good evening, Ms. Teo. I'd like to start by introducing you to the jury. Can you please state your full name and spell your last?
Terry, Teo, Tyo.
Ms. Teo, why are you here today?
They think I was somehow involved with the burglary.
I'd like to start by just talking a little bit more about you, if that's okay. What do you do for a living, Ms. Teo?
I'm a caretaker at Dennis Sloan's ranch.
As a caretaker on Miss Sloan's ranch, what are your job responsibilities?
Just whatever Miss Sloan needs to keep things running smoothly around the ranch and the house.
Could you give us some examples of some of the things Miss Sloan has needed?
Like cleaning or running errands. For example, all the ranch hands wear the same Texas steer steel-toed work boots, and I'd be the one to go out and buy them for everyone.
Ms. Teo, are you responsible for maintaining the property?
Yes, I make sure everything around the house and the ranch look good and clean. And I try to fix anything that's broken.
Now that we have a better understanding of your job responsibilities on the ranch, I'd like to shift your focus to your relationship with Miss Sloan. How long have you been working for Miss Sloan?
17 years.
And after 17 years, how would you characterize your relationship with her?
I don't have any family of my own, so I consider Miss Sloan to be like a mother to me.
How so?
She always tries to look out for me and help me when she can.
How has she looked out for you?
Recently, she knows that if she has to sell her house, I would struggle, so she gave me $25,000 to make sure I'd land on my feet.
Did you talk to any other employees about that $25,000?
No, I know all the other employees who struggled too with Miss Sloan sold the house, so I told them the money came from my boss.
Let's move on to the night before the burglary. Where were you on the night of October 28th, 2021?
I was in my house in the caretaker's cottage.
Did you hear anything outside that night?
No, the cottage is far enough away from the house where I wouldn't be able to hear anything.
Miss Teo, are you aware of any alarm systems in place at the house?
Yes.
Were they active that night?
There's a contact alarm on the back French door, but it was not active that night.
Why wasn't it active that night?
It was broken. I tried to fix it, but I just didn't have the part.
Miss Teo, were there any other safety measures in place that night?
Yes, there were security lights on the side of the house. They were shining down instead of out, though, so I fixed them so they would shine out.
After you fixed them, were the lights working?
Yes.
The day before the burglary, were you working around the house?
Yes, I was doing some yard work and cleaning up around the terrace.
Is that type of work typical of your job responsibilities?
Yes, it is.
Let's move forward to when you actually heard about the burglary. How did you learn of the break-in at Miss Sloan's house?
When Miss Sloan got back from New York, she paged me over to her house and showed me all the broken glass in the den.
Did you know anything about it before?
No, I had not heard or seen anything.
Miss Teo, did anything stand out to you when you went to the house?
Yes, there were some smashed picture frames.
Let's talk about those smashed pictures. Did you see them?
Yes.
What were the pictures of?
All the pictures that were smashed had Miss Sloan's exploits in them.
Now that we know how you heard about the burglary, let's talk about what happened afterwards. Did Miss Sloan call the police?
Yes.
What happened after they left?
I fixed the broken glass on the door, and I called the alarm company to fix the contact.
Was that it?
Miss Sloan also then had me deliver a box.
I'd like to talk about that box for a second. Where did you deliver it?
A DHL drop-off point in Armadillo.
Did that stand out to you at all?
Well, Miss Sloan usually ships through FedEx.
Does she always ship through FedEx?
No, she doesn't always ship, so it was only a little strange.
Miss Teo, do you know what was in that package?
I do not.
Considering the amount of time you've spent working around the ranch, I'd like to shift your focus to other people you've seen spend time there. Have you seen any people around the ranch?
Of course I have.
Who have you seen?
Coco Remington, Miss Sloan's ex-girlfriend, and her
Do you have a relationship with Coco Remington?
Yes.
How would you describe that relationship?
I dealt with her almost every day she was living with Miss Lowe. I didn't like her very much.
Let's talk about her sister. What's her sister's name?
Duke Remington.
And what does Duke Remington do for Miss Sloan?
Duke was a ranch hand.
How long has Duke worked for Miss Sloan?
He worked for Miss Sloan for about 8 months before graduating.
Do you know anything else about Duke Remington, Miss Teo?
I know Duke got out of prison right before he was hired.
Miss Teo, I'd like to talk about why we're here today. Were you in any way involved in this burglary?
Absolutely not. Miss Sloan is too important to me. I would never betray her trust.
Nothing further.
Yes, Your Honor.
Ms. Tayo, you think that Duke or Coco Remington may have had something to do with the break-in?
I do.
Let's talk about your relationship with the Remingtons. You know Duke Remington,
Yes, he worked at the ranch.
and you wouldn't have hired Duke Remington.
I personally would not have, having him just got out of prison.
And you know Coco Remington,
I do.
because Coco Remington was Dennis Sloan's former girlfriend.
Yes.
And you don't like Miss Remington.
I do not. I thought Miss Sloan could do better.
You thought Miss Remington was low class.
I did.
You thought she was a little common.
Yes.
Ms. Tayo, let's speak now about the events of the 28th. On October 28th, 2021, you were home.
Yes.
And when you say you were home, that means you were in your cottage.
I was watching TV.
And that's your cottage on Dennis Sloan's ranch.
Yes, I live in the caretaker's cottage.
And that day, you knew that the alarm contact on the French door that led to the flagstone patio was broken.
I did. I tried to fix it, but I could not.
And when you tried to fix it, Dennis Sloan told you, don't worry about it.
Well, it wasn't a top priority concern, and Miss Sloan was running out to New York.
And you also knew that the interior alarm system in Miss Sloan's home was turned off.
I did not know that.
You knew that Miss Sloan was going to be out of town that day.
Yes, I did.
And you were home alone.
Yes.
Objection are asked and answered.
Response?
Yes, Your Honor, I believe I asked whether or not Ms. Tayo was home and that her home was her cottage on the ranch. I don't believe I asked whether or not she was home alone.
Overruled.
You were home alone,
Yes, I was watching TV.
and you didn't see anything that night,
No, the cottage is far enough away from the house where I did not see anything.
and you didn't hear anything that night.
I did not hear anything.
Now let's speak about the next day. Miss Sloan asked you to deliver a package.
That is true.
And she asked you to deliver that package via DHL.
Yes.
And this was unusual.
Yes.
This was unusual because Miss Sloan has a contract with FedEx.
Yes.
And Miss Sloan told you not to worry about that either?
Well, Miss Sloan told me not to worry, but there were so many things happening that day at the ranch, like me fixing the broken glass and dealing with the alarm company, that I just didn't have to stress about it.
You testified earlier you do the things Miss Sloan asks you to do.
Regarding my job with keeping the ranch run smoothly.
So you delivered that package.
Yes, that's part of my job.
And then Miss Sloan gave you $25,000.
Miss Sloan gave me $25,000, not having to do with the package.
And you don't have any family,
No, I do not.
and that includes not having any aunts.
Objection, Your Honor, cumulative.
Overruled.
I'll re-ask. And that includes not having any aunts.
It does.
And yet, you told people that $25,000 came from an aunt.
Yes, I didn't want them to be heard that they were not given $25,000 as well.
Sloan didn't want anyone to know that she gave you that $25,000. I assumed that she had shared the same sentiment as me. Let's talk about your relationship with Miss Sloan. You worked with Miss Sloan for a long time.
Yeah, almost 17 years.
And you live there on the ranch.
I do.
And if Miss Sloan were to lose that ranch, you wouldn't be employed there as the caretaker anymore.
I would not have a job, that's correct.
And you wouldn't live in your cottage there on the ranch anymore.
No, I would not.
You have a close relationship with Miss Sloan.
I do.
Miss Sloan is like a mother to you.
She is.
No further questions, Your Honor.
Redirect?
Briefly, Your Honor. Ms. Teo, do you ask Ms. Sloan about the contents of packages you deliver for her?
I never do. It's a very ordinary task. It would be exhausting to always know what I was shipping out.
Do you regularly conduct activities like delivering packages for Ms. Sloan?
Yes, I often run errands for her.
If Ms. Sloan sold the house, would you be okay?
Yes, that's a big reason that she gave me that money, so I ran on my feet, be able to find a new home, and I have 17 years of work experience. I'm not too worried about finding a new job.
Nothing further.
You're welcome to step down.
Your Honor, may I request a recall solely for the purpose of impeachment?
Given the time, respectfully, no.
Yes, sir.
But if you want to make a very brief offer of proof.
Yes, Your Honor. On cross-examination, witness Terry Tayo said that she did not know that the interior alarm system was turned on. And at the bottom of page 39 in her deposition, she was asked, would Coco or Duke have known that the interior alarm system was not turned on? She said, not that I know of. She was then asked, but you knew that thing, right? And she said, I suppose so.
All right, thank you. So we don't need to. You're welcome to step down. Thank you. And does the defense have any additional evidence they wish to present?
Yes, Your Honor. The defense calls the defendant, Ms. Dennis Sloan, to the stand.
You promised to be truthful.
Yes.
Counsel.
Good evening, Ms. Sloan. Please state your name. Spell your last for the record.
My name is Dennis Sloan, S-L-O-A-N.
Why are you here today, Ms. Sloan?
I'm here because my house was burglarized back in October of 2021, and now I'm being accused of committing insurance fraud.
We'll talk about that, but first I want to give the jury a chance to get to know you a little bit. Where do you live?
Currently, I live at 6734 12 Oaks Boulevard, Armadillo.
How long have you lived there?
Since 1995, but I recently put that property up for sale.
Why did you put that property up for sale?
There's a number of reasons. It's become expensive to upkeep it, and I don't need all that space for just myself. I've also gotten a little behind on my mortgage payments.
Now, you mentioned earlier that your home was burglarized. Is this the same home that you're currently living in?
Yes, it is.
So I'd like to spend some time now talking about this burglary. When did this occur?
On October 28th, 2021.
Where were you on October 28th, 2021?
I'd gone out of town for the evening to a charity benefit in New York.
How long were you planning on being out of town?
Just for the night, I was going to come back in the morning.
Did you tell anyone that you were going to be out of town?
Yes.
Who did you tell?
I told Terry Teo, who's my caretaker, and then the pilot of my jet, of course. And I also think I told my ex-girlfriend, Coco Remington.
Okay, we'll come back to discussing these people that you told about your trip, but first I want to finish talking about this burglary. When did you first discover that your home had been burglarized?
Shortly after arriving home from New York.
Describe for us what happened when you arrived home that morning.
Well, I didn't notice anything right away because I came in through the side door of my house and went upstairs to change. But when I came back down and went into the den, that's when I noticed there had been a break-in.
What did you notice when you entered the den?
First, First, I noticed that the door to my safe was wide open, and then I also noticed that certain photographs had been smashed on the floor.
Was there anything missing from the safe?
Yes.
What was missing?
My ex-wife's jewelry was missing.
We'll come back to the missing jewelry, but first I want to talk about the rest of your house. Did you notice anything else out of the ordinary in any other part of your home?
Yes, I did.
What did you notice?
Well, a pane of glass in the French doors in the rear of my home had been broken, and there were also some footprints on the floor.
Tell us what the extent of damage in your home was.
So just the pane of glass, mud on the area rug, and then all of the photographs in my den that had my ex-wife in them had been smashed.
Were there photographs in your den that did not have your ex-wife in them?
Yes, all the photographs that just had my daughter or just myself and my daughter, those were untouched.
Now back to the jewelry. Was the safe containing the jewelry damaged?
No, just open.
Do you remember if the safe had been locked before you left?
I'm not sure, I don't remember.
So now that we've heard about the items that were damaged, I want to get back to the stolen items, the jewelry. Now you mentioned that your ex-wife's jewels were missing. Was there anything else missing in your home?
As far as I could tell, just the jewelry.
Let's focus on that then. Miss Sloan, do you keep the combination to your safe in your house?
Yes, I did.
Where did you keep it?
I kept it on a small piece of paper underneath the ink blotter on my desk.
To your knowledge, did anyone else know where you kept this combination?
I think my ex-girlfriend, Coco Remington, knew.
Objection, Your Honor, lack of foundation, lack of personal knowledge.
Response?
Yes, Your Honor, I believe the foundation has been laid that Miss Sloan had the combination, if we may approach. Miss Sloan.
You have.
Miss Sloan had the combination, kept it in her house. The question was, do you know, to your knowledge, did anyone else know? And I believe she was just answering that question. This is laying the foundation for how she knows that and why she thinks that.
Well, at this point, the objection is sustained. You're welcome to try to lay additional foundation.
Yes, Your Honor. And just for a clarifying point, was that to the question of, to your knowledge, do you know if anyone else knew where the combination was?
Yes.
Okay. Where did you keep the combination?
Underneath an ink blotter on my desk.
Did anyone else have access to your desk?
Yes, well, my ex-girlfriend, Coco Remington, did.
And did she know where the combination was?
I think she might have found it.
Why do you say you think she might have found it?
One day I walked into the den and she was sitting behind my desk. When I walked in, she crumpled a piece of paper in her hand.
So let's talk a little bit more about Miss Remington in general. You mentioned that she's your ex-girlfriend. When did that relationship end?
I broke up with her in late September 2021, about a month before the break-in.
Were you still in communication with her when the burglary occurred?
Yes, I actually spoke to her the day I left for New York.
What was the nature of your relationship like at this point?
Well, we still had some affairs that were entangled, and her sister, Duke Remington, worked at my ranch, so we spoke from time to time.
Were you on good terms with one another?
Not really. The last time we spoke, she threatened me.
Objection, Your Honor, hearsay.
No, overruled at this point. You're welcome to proceed.
Miss Sloan, how did she threaten you?
I said I was going out of town to this charity benefit, and she wanted to come along as my date. I told her that wasn't appropriate because
Objection, Your Honor, hearsay, as to...
All right, well, imagine you've approached. Do you want to elaborate on your objection?
Yes, sir. Even the statement of the witness right now, her past statements are hearsay, as she's offering them to prove the truth of what she said in that conversation. I'm imagining the response to Coco, that she's going to give us more details about this alleged threat, are also going to be hearsay as well.
Response?
Yes, Your Honor. First of all, threats under the hearsay rule do not constitute hearsay. Second of all, if I may make an offer of proof,
Why don't they constitute hearsay?
because they hold legal ramifications potentially. As such, they are not being offered for the truth, but rather for the effect that they are a threat. Furthermore, this also falls under 8033, the exception to hearsay, as a state of mind statement. If I may offer what the threat is.
Please.
The threat will be, you'll be sorry that, or I would be, she said to me, I would be sorry that I said that. As such, this shows motive and intent for the burglary that occurred the next day after this. And given the rest of the statements, those are being offered for context, so the jury does not take a threat out of context in the spirit of completeness here.
The objection's overruled based on the response under 8033. You may proceed.
I'll re-ask that question. Ms. Sloan, how did Ms. Remington threaten you?
When I told her I was going out of town for this charity benefit, she wanted to come along to my date. I told her that would be appropriate because she wasn't my wife and never had been. And she said I would be sorry that I said that and hung up.
Have you had contact with Ms. Remington again after this?
No.
So now that we know about your relationship with Ms. Remington and the burglary, I want to get back to why we're here today. Did you report this burglary to anybody else other than the police?
Yes.
Who did you report it to?
I filed a claim with my insurance company.
How much was your claim for?
$386,900.
Did you receive any payment from your insurance company?
No, I did not.
Okay, let's back up a little bit, back to before the burglary, to the burglary. Now you mentioned that you had told Ms. Teo that you were going to be out of town that evening. To your knowledge, did she have anything to do with the burglary?
No.
To your knowledge, did any of your staff have anything to do with the burglary?
Well, given the footprints that were found, I do think someone on my staff might have been involved.
Objection, Your Honor, calls for speculation.
Overruled. The answer stands. You're welcome to continue.
Sorry, would you?
Please continue.
Yes, Your Honor. Would you like me to repeat that question?
I don't know if there's a question pending at this point.
So she answered. Okay, sorry, just making sure you're right. Ms. Sloan, why did the footprints indicate to you that someone on your staff had something to do with the burglary?
Objection, Your Honor, this calls for an opinion by lay witness under 701.
Response?
Yes, Your Honor. Under 701, this is rationally based on the witness's perception. Here, we are simply connecting the dots. She already answered the question that, given the footprints that we've all heard about today, including the defendant as she is not sequestered, she believes somebody in her staff had something to do with it. We've heard testimony, as has the defendant, that other people on her staff wore the same shoes. As such, this is rationally based on her perception. It's not based on any scientific or specialized knowledge, and it will help the trier of fact under 701.
You seem to want to say something.
I do, Your Honor. There's been no foundation laid by the defense counsel that there's any reason that Ms. Sloan, even though she may have seen dirty footprints, did any sort of forensic analysis to compare those footprints to the boots that she provided to her staff. Outside of the detective's testimony today, I'm not sure she would know that.
Sounds like a cross to me. So the objection's overruled.
I'll re-ask my question, Ms. Sloan. Why did the footprints indicate that somebody on your staff may have been involved in the burglary?
Because I buy the same work boots for all my ranch hands and helpers.
Did you suspect any one of your employees in particular?
One of my employees is an ex-con and also related to my ex-girlfriend, so I suspect her.
Which employee is this?
This is Duke Remington.
Did you ever speak with Ms. Remington about your suspicion?
Yes, I fired her shortly after the burglary.
Now, to your knowledge, did Ms. Remington know where you kept your ex-wife's jewelry?
I don't know.
To your knowledge, did Ms. Remington's sister, Coco Remington, know where you kept your ex-wife's jewelry?
Yes, she did. It had actually been a major point of contention for us.
What do you mean it had been a point of contention for you?
Coco said jewelry was meant to be worn. She wanted to wear it
Your Honor,
out.
hearsay.
Response?
Yes, Your Honor. Again, this is not being offered for the truth. Rather, it's being offered for the effect on the listener as to why this was a point of contention between Ms. Remington and Ms. Sloan. The previous question was, what do you mean this was a point of contention for you two? As such, this is going to back up the effect of why she thought it was a contentious issue between the two of them.
Only because I want to hear it, I'm going to overrule the objection.
Yes, Your Honor. Ms. Sloan, what do you mean the jewelry was a point of contention between you two?
Coco said jewelry was meant to be worn. She wanted to wear it out and about, even though I told her I was keeping it for my daughter.
Ms. Sloan, did you stage a burglary at your house?
Absolutely not.
No further questions.
Ross?
Yes, Your Honor. Good evening, Ms. Sloan. I want to talk a little bit about something we just heard about, some boot prints. Did you conduct any forensic analysis of the boot prints in your home?
Objection, 701.
Overruled. You may answer the question.
No, I just saw the footprints once I realized there was a break-in.
Do you have any expertise in footprint forensics?
No, but I see those footprints all over my ranch.
Did you compare the footprints in your home to footprints of people in the range?
I had a lot going on. My house had just been burglarized.
So that's a no?
No.
I want to talk a little bit about your financial situation as of October of 2021. So you were having financial distress in October of 2021.
Yes.
You had lost a lot of money in the financial collapse due to the Enron scandal.
Yes.
You had fallen behind in your mortgage.
Yes.
Fallen behind in your mortgage to the tune of $325,000.
Yes, so I was selling my property.
And the bank was about to begin foreclosure proceedings against your home.
Yes.
That must have been very stressful.
Yes, I was selling my property.
I want to talk now about your behavior and your actions on October 28th. You got a phone call from a friend.
Yes, that morning.
Your friend invited you to a charity benefit in New York City.
I think I'd already been invited, but they were begging me to attend. I hadn't been planning on it.
And the benefit was that night. It was October 28th,
Yes.
the same day.
Yes.
Okay. So you took your jet to New York City.
Yes.
You attended the charity benefit.
Yes.
You stayed overnight in the Ritz Hotel.
Yes.
And you took your jet back to the range.
Yes.
Okay. I want to talk about how much all of that must have cost. Usually, flying a private jet costs money.
Objection, relevance.
Overruled. You may answer.
Usually, let me repeat, usually flying a private jet costs money.
Yes.
You gotta pay your pilot,
Yes.
you gotta buy your jet fuel.
Yes.
When you attend a charity benefit, people usually have to purchase tickets to attend one.
I suppose.
It costs money to stay overnight in the Ritz Hotel,
Yes, a little money.
and it costs money to fly back home.
Yes, again, not that much.
Allow me to summarize and put this all together. So in October 2021, you were having financial distress to the level that your house is about to be foreclosed upon, and you take a trip to a charity benefit in New York in a private jet.
Objection, compound question.
Sustained. Rephrase.
Yes, Your Honor. To summarize, Ms. Sloan, you were having financial distress such that the bank was about to foreclose on your home in that month.
Yes, I was in a bit of financial trouble, but I was selling my property.
And you took a round trip to a charity benefit and back in your private jet.
Yes, which relatively did not cost that much money.
I want to talk a little bit about money a little bit further. The day after the break-in, you withdrew $25,000 from your money market account.
Yes.
In cash.
Yes.
And you paid that money to Terry Tile.
No, I did not.
You did not pay that money to Terry Tile.
I did not. That was for living expenses.
You paid money to yourself for your own living expenses?
I withdrew money for living expenses.
For yourself?
Yes.
You did not pay Terry Tile $25,000 to stay break-in.
Objection, asked and answered.
That question has not been asked and answered.
Do you have another objection?
No, you're on.
You're welcome to restate the question.
You did not pay Terry $25,000 to stay break-in?
No, I did not.
A few days after the break-in, you filed an insurance claim.
Yes, I wanted to get back this money I lost.
You filed an insurance claim for 6 pieces of jewelry,
Yes.
and the totals of the values of that jewelry equals $80,900.
Yes.
The day after the break-in, you also asked Terry Tayo to ship a package.
Yes.
You asked Terry Tayo to ship a package that contained valuables.
Yes, I'd just been burglarized, so I was worried about other valuables I had lying around my house, got paranoid, and shipped them out.
So the package contained valuables from your home,
Yes.
and you instructed Terry to ship that package to a Swiss bank.
Yes. That's where the package was going, to keep my valuables safe.
And you insured that package for roughly the same value as the amount you claimed on that insurance form.
I think it's a few $1,000s different. I don't think it was exactly the same
It was
value.
roughly the same value.
Everything's relative, sure.
No further questions, Your Honor.
Redirect.
Yes, Your Honor. Ms. Sloan, why did you ship valuables away?
My house was just burglarized. I was worried that my house wasn't safe and I had other valuables lying around I wanted to protect.
Why didn't you use FedEx to ship your items away?
There was so much going on. FedEx had already come that day, and I thought it would be easiest to just have Terry take care of it.
And Ms. Sloan, why did you withdraw $25,000?
For living expenses.
No further questions.
All right, any additional evidence for the defendant?
No, Your Honor, the defense rests.
Any issues that we need to take up before we proceed to closing arguments?
Yes, Your Honor. The defense re-raises its motion for a judgment of acquittal based on the same reasons we provided earlier. We believe, considering all the evidence in the light most favorable to the opposing party, no reasonable jury could find for the prosecution.
Okay, that motion's overruled, and do we want to take a short break before we go to closings? Okay. That was a definite. Why don't we? Shall we take 5?
Yes, Your Honor.
Okay, 5 it is. We're in recess.
All rise.
Thank you. Please be seated. All right. Closing arguments first for the people.
Yes, Your Honor. To reserve 3 minutes for rebuttal.
All right. Keep track of your own time.
Dennis Sloan was a desperate woman who took the easy way out. As you heard today, Dennis Sloan was used to living a lavish lifestyle. The kind of lifestyle where you get a phone call from a friend in the middle of the day begging you to come to New York City for a charity benefit, and you say, sure, why not? Where you hop on your private jet, you go off to New York, you stay overnight in the Ritz, and the next morning, you're home again. The kind of lifestyle where your house is actually a mansion, situated on acres of beautiful ranch land. You have staff and employees to take care of your property. Dennis Sloan had it made. As you heard today from the defendant, however, she started to experience financial difficulties. With the exposure of the Enron scandal and the collapse of the financial markets, so too fell her financial situation. She started to fall behind on her mortgage, to the tune of $325,000. The bank's foreclosure proceedings were imminent. Her lifestyle, her home, her ranch, her mansion was all on the line. But all was not lost. Because there in a safe in her den lay the keys to her financial redemption. 6 pieces of fine Cartier jewelry worth well over $380,000. This jewelry belonged to her ex-wife. They were keeping it for their daughter. Certainly, Miss Sloan wasn't going to miss this jewelry at the time. Her ex-wife wouldn't miss it. Her daughter wouldn't miss it. So she hatched a plan for this jewelry. She promised Terry Tayo $25,000, staged a break-in, while she jetted off to New York overnight on October 28, 2021. When she arrived home the next morning, she was not surprised to see that empty safe. The safe, coincidentally, that was not damaged. It might never have been locked in the first place. You heard today that she told police. She told police that she had not turned on her alarm system. Another coincidence. Later that same day, Ms. Sloan withdrew $25,000 from her bank account in cash. You heard from Ms. Tayo that Ms. Sloan gave that $25,000 to her on that day, and you heard Ms. Sloan deny that very act. You heard that Terry Tayo was instructed by Ms. Sloan to ship a box, and you heard from the defendant that she had collected valuables in her home, put it in that box, and they shipped that box to a Swiss bank, far out of the reach of the Bexar County Sheriff's Department. That box was insured for $385,000. A few days later, Ms. Sloan filed an insurance claim for roughly the same amount of money. That was the easiest step of all. We saw that claim today, and we saw that she told the insurance company that there had been a burglary and someone had stolen tools, but we know that it is no coincidence that box was on its way to Switzerland, insured for the same amount. Folks, Dennis Sloan knowingly and intentionally committed insurance fraud. We simply have to follow the facts. We have to follow the money. First, that Ms. Sloan was behind on her mortgage by $325,000. Second, that the day after the burglary, she withdrew $25,000 in cash. Third, that she instructed Ms. Tayo to ship a box of valuables to a Swiss bank. Fourth, that she insured that box for $385,000. And finally, that she filed an insurance claim on November 4th for over $380,000. There are three elements of insurance fraud that we have to prove to you today beyond a reasonable doubt, and we have proven each element to you. I'm going to describe elements one by one and describe to you how we met our burden today. The first element is that Dennis Sloan wrote an insurance claim, wrote a statement and sent it to her insurance company in support of a claim for lost or stolen valuables. We saw that in Exhibit C. Today we saw the claim that it was notarized and that it had Ms. Sloan's signature on it. That, of course, is not in dispute today. The second element of insurance fraud is that Ms. Sloan knowingly included false statements on that claim material to the case at issue. And we know that when Ms. Sloan wrote that that house had been burglarized and her jewelry had been stolen, that this indeed was not true. We know that Ms. Tayo was home alone, that her boot prints matched that outside the house, that Ms. Tayo's fingerprints were on the door, and that Ms. Tayo received $25,000 the next day, and that Ms. Tayo had shipped that box of jewelry to a Swiss bank. The third element of insurance fraud is that Ms. Sloan intended to defraud Lone Star State Insurance Company. We see intent written all over today's case. As we follow the money trail, we can see that Ms. Sloan, despite the imminent foreclosure upon her house, behaved in a way of the weekend of the October 28th of someone who was not concerned about her financial situation, who proceeded to give money to her favorite employee, a large sum of money, and then got up on the stand today and told us that she did not give that money to her employee. Folks, we as the people do carry the burden today of proving each and every element beyond a reasonable doubt, and I want to describe what a reasonable doubt is. A reasonable doubt is not a possible doubt, it is not speculative, imaginative, or a forced doubt. Instead, it is your job to carefully consider, compare, and weigh the evidence that is laid out before you. To look at the facts, to look at the evidence, and to follow the money. Ms. Sloan was a desperate woman. But today, you can find her guilty because of where the evidence, the facts, and the money lead. When you find her guilty, she will not get her easy way out.
Defense closing argument.
Yes, Your Honor.
Now that I've figured out which chair I'm supposed to be in, you're welcome to proceed.
Crippling coincidences. A weekend away, broken alarms, and someone to blame. This case is a story about a successful entrepreneur, exploited by the very people she trusted most. Miss Sloan represents the very best of us. After making a fortune in oil and gas and the stock market, she could have easily left her small hometown of Armadillo, but she didn't. A household name in the city, she remains committed to improving her community. She regularly attends charity events, supports businesses, and as an employer, hires citizens of Lone Star looking to create a better life. Unfortunately, it was her own altruism that would end up costing her. This case is a story about stolen jewels. Since 2002, Miss Sloan has been carefully protecting valuable jewels, with the hope of one day gifting those jewels to her young daughter. The only critique of Miss Sloan's actions leading up to the burglary of her house on October 28, 2021, is that she trusts her employees, that she believes people deserve second chances. Until September of 2020, Miss Sloan had been in a relationship with Coco Remington. The relationship mattered so much to her that she even hired Coco's sister, Duke Remington, an ex-felon convicted of dealing in stolen property. Throughout the relationship, Coco regularly talked about Miss Sloan's jewels, going so far as to ask Miss Sloan if she could borrow the jewels, wear the jewels, keep the jewels. The prosecution comes here today and asks you to find Dennis Sloan guilty of committing insurance fraud. If I could please turn your attention to page 49 of your jury instructions. I'll summarize as you read. For you to find Miss Sloan guilty, the prosecution must prove the following three elements beyond a reasonable doubt. First, that Dennis Sloan filed a statement in support of an insurance policy. Next, the statement contains false or misleading information. And finally, that Dennis Sloan intended to defraud Lone Star State Insurance Company. Miss Sloan has entered a plea of not guilty, meaning you must presume her innocence. Innocence that stays with her through each element, unless it's overcome by the evidence beyond a reasonable doubt. It's up to you to decide what evidence is reliable and what to consider when making your decision, but most important, the burden of proof is entirely on the prosecution. It's up to them to make the case that Dennis Sloan committed insurance fraud. If they fail to do so, or if there's even a single reasonable doubt at all that Miss Sloan's house was in fact broken into and the jewels were stolen, you must find Dennis Sloan not guilty. And the prosecution has failed. They haven't met their burden. They can't. Let's consider what we've heard today. The prosecution paints a picture of Miss Sloan as a woman in desperate need of money. Someone willing to hatch an elaborate scheme to stage a break-in into her own house, but ask yourself, what's more likely? A staged break-in or a burglary? Don't let the prosecution shift their burden. For them to win, they have to prove that insurance fraud happened and Dennis Sloan is the one who did it. But Miss Sloan told you she wasn't even in the state on the weekend of the burglary. Every piece of evidence indicates that the jewels were stolen. First off, the jewels were in a safe. Several of Miss Sloan's longtime employees both knew where the safe was and knew the combination. Members of the jury, that's reasonable doubt. What's more, Coco Remington threatened Miss Sloan that very weekend. Her words could not have been more clear. Miss Sloan would be sorry. And she certainly had the means. Her sister Duke was working on the ranch. And as an ex-felon convicted of dealing in stolen property, she certainly had the experience. Rewind just a few weeks and the state would never have tried this case, but they got lucky. Lucky that Coco Remington disappeared, preventing us from calling her to the stand. Lucky that their own detective, Taylor Wise, who literally saw Coco wearing one of the stolen rings, didn't ensure that she would stay in Armadillo. The prosecution tells you these facts don't matter. that it's just an unfortunate coincidence that Coco Remington disappeared the same weekend that Jules went missing. That is reasonable doubt. But the prosecution didn't get lucky enough. Their detective was incompetent, and the burglars left evidence. First, Detective Taylor Wise's investigation was a joke. From the second she arrived at the scene of the crime, she'd already decided the burglary was staged. You heard the scope of her investigation. She talked to Duke Remington, and before she disappeared, she talked to Coco Remington. That was it. Case closed. The detective knew that Miss Sloan was a household name in Armadillo. She knew that Miss Sloan had several employees, many of them who knew where the safe was and knew about the combination. You heard about the broken glass pane. The detective couldn't even bother to wait for the results of the fingerprint test before concluding her investigation. Again, that's reasonable doubt. Additionally, the scene of the crime exonerated Miss Sloan. You heard about the footprints found near the house, footprints that were roughly a size 8, the exact same size of Duke Remington's boots. You also heard about the damaged pictures found inside the house. In each of those pictures, Miss Sloan and her ex-wife. The pictures of Miss Sloan's young daughter were left completely untouched. Duke and Coco slipped up. The prosecution's entire case rests on the theory that Miss Terry Teo, Miss Sloan's caretaker, helped stage the burglary and ship the jewels to Switzerland. They tell you that footprints that might have been hers were found near the crime scene, but once again, ask yourselves, what's more likely? That a caretaker whose job is to take care of the house was taking care of the house? Or that she staged a break-in and randomly decided to smash a bunch of pictures of Miss Sloan and her ex-wife? The only evidence the prosecution brings are a $25,000 gift, potentially to Miss Teo, and footprints that might have been Miss Teo's found near the crime scene. But they can't tie that $25,000 to anything but a gift. And you heard Miss Teo tell you everyone around the ranch wears the same boots. The prosecution's evidence is at best circumstantial, and at worst, it's irrelevant. The presumption of innocence is the foundation of our justice system. Dennis Sloan is innocent unless the prosecution can prove that she's not. They've fallen far short of their burden. They have not proved that Dennis Sloan staged a break-in into her own house. They have not and cannot prove beyond a reasonable doubt that Dennis Sloan committed insurance fraud. In just a few minutes, when you return to your jury room for deliberation, all I'd ask is that you do exactly what the jury instructions ask of you. I'd ask that you find Dennis Sloan not guilty. Dribbling coincidences. A weekend away, broken alarms, and a scornful ex. Don't make an innocent woman pay the price.
No closing for the people.
Yes, Your Honor.
Please.
Your Honor, Dennis Sloan is indeed a desperate woman, and she attempted to take an easy way out. The defense counsel would like to paint Miss Dennis Sloan as a model citizen. The very best of us all. But folks, what you heard today as in Miss Dennis Sloan's erratic behavior is not that of a model citizen. While her home is in the midst of foreclosure, she takes luxury trips. While she cuts all of her employees' pay, she gives her favorite $25,000. While she knows what happened to her jewelry, she pointed fingers at an easy target, Miss Duke Remington, accusing her of being an ex-con, and if she did it again, she did it in the past, she will do it again, and had done it. Without proof, she fired Miss Sloan. Ms. Remington on a dime, dismissing her from her services. As you heard today, Ms. Duke Remington's job performance had no poor performance reviews. And there was no proof of Ms. Sloan prior concerns. You see, the facts show us, the evidence shows us, and the money trail leads us to see the desperation of Ms. Sloan in trying to salvage what she had left of her luxurious lifestyle, of the plan she hatched with her caretaker, devoted Terry Tayo, and that they successfully sent those pieces of jewelry off to a Swiss bank. Folks, we simply have to follow the money. Ms. Sloan was desperate. She saw an easy way out. And when you look at the facts before you today and find Ms. Sloan guilty, you'll make sure she doesn't get that easy.
Thank you. All right, well done, guys. So we'll retire for a month. There's nothing else we need to address out here right now. We'll go back and vote, and we'll be out in hopefully about 5 minutes. All rise. All rise. Please be seated. Thank you. So, both sides did a terrific job. Right? We actually ended up with a split decision. So it feels like there should be a drum roll. The split decision was in favor of the defense team, and so congratulations. And Best Advocate is awarded to Ms. Schneider.
So what we're gonna do is just go down the line and offer some individual critiques. You all did fantastic, and I think sometimes you learn more from constructive criticism than you do from praise. So it's not that, so I'll offer some on that. And I think my biggest overall comment for all of you is, I know it's hard because how many times have you tried this case in the last few days? Six.
You're wearing it in your sleeve, right?
Right, no doubt. But, and I can sort of sense that because you had done the exam and the cross so many times, particularly the direct, you knew what the answer was. Try to look surprised, try to look like you don't know what the answer is. So as you go on your further competitions, to which I assume you'll make finals, make it look like the first time you tried it. So that applies to all of them. So I'm just going to go down. I'm going to go down the line and just offer a few comments. Suchinder, thank you. I thought your closing was outstanding. You had really good tone and cadence. And one interesting thing I saw in your performance is during direct exam, you did a really good job having a conversation with the witness and talking to the witness. During the cross, you were looking at us a lot, which I think a jury or judge might find distracting. But again, a terrific close. And then Phoebe, you did a very good job in your opening describing the burden. And I think for all of you who are objecting a lot on hearsay when foundation is typically the more common way to say that, because of course the foundation is based on hearsay. But so I encourage you to think about that. And okay, your cross-examination of the, your direct of your client, I thought had really good pace and poise there and was terrific. All right, and then, Caitlin, I also thought you had really good natural poise, really good gesturing, like following the money. One thing I was looking for you to do was one of the best tools a prosecutor has, and Justice Hood and I are both prosecutors, is that rebuttal. Is the rebuttal closing and responding and turning their theme against them. Another thing I think for all of you is make sure your opening and closing have consistent themes. We've seen that in the past years. I didn't hear a lot of it this year. So remember that as well. And then Alexis, and the opening I liked a lot, but talk a lot about what the evidence will show. And remember to incorporate it, because that's really what the opening is supposed to be focused on, telling the fact finder what the evidence will show. And yeah, so I know you all want to get into the reception, so I'll keep it there.
Everybody wants to get to the reception, right? So I'll try to keep it brief. Just moving to the opening statements quickly, which doesn't sound like I want to keep it real brief. Ms. Opper, right? So I like the purposeful movement. You guys have obviously been coached to do that well. There's not this sort of mindless roaming around, so it's good. But I think apropos of what Mr. Carrigan here was saying earlier, it at times seemed a little too mechanical. I think maybe because you've done it so many times, it just, so I would say just loosen up a little bit. I thought in the defense opening, that, if she chooses to testify, and then you make it clear that she's going to testify, it was a little odd, right? So, pick a horse and ride it. Then just jumping into the direct exams by the prosecution, love the timeline, get a better marker, right?
Yeah.
If you're going to use props, make sure the props work, right? And so it sounds like a little thing, and I suppose it is, but you'd be amazed how many times in the real world that becomes an issue too. So you really want to think through your props. Just a general observation on cross, I thought sometimes both sides were getting a little argumentative with their crosses, and sometimes you probably heard this expression, the one question too many, right? Where you're asking the witness ultimately to agree with your closing argument, and you don't want to do that. You want to just ask those nice, tight, single fact questions that both sides at times were doing really well. And then don't ask that one question too many. Save that final question. And isn't it true that you're guilty? It's no. You just save it and make your point in closing about what all those facts add up to. So both sides need to be a little bit more careful about that. And, the closing arguments were good on both sides. I was telling my colleagues here that I have this sort of personal aversion to over-reliance by the defense on the beyond a reasonable doubt standard, because to me it starts to sound like, sure, she's kind of guilty, but she's not beyond a reasonable doubt guilty, right? And instead of just emphasizing that it's a really kind of weak circumstantial case in a way, so, but I did think that your style, which is kind of big, right, was well suited to closing argument. I think, and I'll just finish with this point, because you've got some really good stuff going on there, but you just need to rein it in at times when you're in other segments, and maybe modulate your tone a little bit, because you tend to always go big, right? And so I would just encourage you to try to mix that up a little bit. The cross that you did, we should talk about that briefly. This was, which one was it that I was having trouble with? It was the Sloan cross. So you started in with some ad-lib cross where you failed to lead. You knew once you got back into what you had been planning to do, you started leading, right? But you got off, you decided to do some stuff spur of the moment, and it was, do you have any expert? Did you compare? Instead of just putting the answers into her mouth, and so, but more significantly, I think towards the end, it's a classic example of what I was talking about, to summarize. If you find yourself on cross-examination saying to summarize, you're asking the one question too many, right? I just encourage both sides to think about that a little bit. Please.
Thank you. So Chandra, I thought your energy was really great on closing. That was my favorite part of your entire presentation, but I also thought you were very effective in showing the limited investigation that was conducted. I thought those points were very well made. Phoebe, I was super impressed with how facile and nimble you were with the rules, but also your articulation of kind of a more common sense basis for exclusion of evidence or admission of evidence that you were offering. So I thought that was a really great job. Caitlin, I did note on the Sloan Cross that, you know, when you were trying to get that was what drew the compound objection, for example, you were trying to summarize, so save that for closing. But I thought, you know, all of you did an amazing job of not using notes, you know, looking at us, I guess again, 6 times in the last few days, but still, you know, very impressive ability to connect with everybody, the witness, with all of us.
That's true, yeah.
I was impressed by that. I didn't love the theme of the coincidences as much as I liked the desperate woman and easy out theme. That was more concrete for me, and the coincidences were harder for me to kind of conceptualize. So that's just a thought. And I thought you all carried your themes pretty well through. I don't think you mentioned the desperate woman easy out till the end of closing, but then you did it again in the rebuttal closing portion. But at first I had made a note of, you need to go back to that theme. And then at the end that you did that. And Alexis, I thought you seemed really comfortable, really natural, very poised. So I thought that was really good. I thought all of you were amazing, to be honest.
You know, a good example of that was when you left your stuff up at the podium early on and you had, you know, a lot of people would have gotten really flustered then. You were just very cool about it. Okay, I'll get my stuff. Yeah, take it over here. Great.
Yes, but I also had noted that a darker marker would be good for the exhibit. It just wasn't useful because I could barely, even me, and I was closest to it, either a darker marker or a brighter light or both. The witnesses were fantastic too. I never did mock trial except as a witness, but I thought that was
It's so much work for everybody involved, including the witnesses, so thank you guys for doing
great
that.
job. Thank you.
Well, one more thing, I know I speak for all of us, the objections, it's a great opportunity to show your knowledge of the rules of evidence, but just because you can object doesn't mean you should. There was a fair amount of defense. So we were joking that maybe what a good rule for next year would be, you get 12 objections. Use them carefully. So, anyway, but excellent.
Yeah, when you need to really think about when the objection matters. And you know, sometimes there are objections that you can make that are just sort of pointless in the grand scheme of things. So always keep your eyes focused on, you know, the prize, right? Not
When the
just,
detective is explaining what a technical evidence person does, I can't remember their title, but you were like, not an expert, and it was like, oh, who cares? Like, we got it.
Good. Well done. Excellent.